Your Lordships.
Yes.
Your Lordships, I beg to mention items 24 to 29. Items 24 to 29. Your Lordship, these repetitions are all analogous.
Yes.
Now, in these repetitions, I am challenging the disciplinary proceedings on the basis of which I have been terminated from service. Now, there are two private respondents. Now, the presence of these private respondents may not be necessary, Your Lordships. And I have taken steps for service of notice upon them on 26/11/25. And office note dated 19/1/26 shows that service report is still awaited. But however, my lords, I'm out of service, and their presence may not be actually very necessary. It's a very short matter. So this matter can be taken up on the coming Wednesday.
Wednesday. All right.
May I please, my lord, Your Lordship? Of course, with due respect to my learned counsel here, Your Lordship, the other two private respondents are the universities who have claimed that the petitioner has never admitted in that university, and the certificate that was being produced by the petitioner to the department is a fake certificate.
That is what they say. But
And therefore, Your Lordship,
no,
they are also a necessary party.
no, Your Lordships. Now, the disciplinary proceedings has been initiated and concluded by adopting a procedure which is unknown to them. So effectively, there is no disciplinary proceeding. That is my case, in short, Your Lordship. So that can be examined only on that point. And if Your Lordships find that their presence will be necessary, then of course we can wait for them. Otherwise, I'm sure, my lords, that I'll be able to satisfy Your Lordships on that point. There was no disciplinary proceeding.
Okay. Okay.
Yes. On 28th month.
Okay.
Yes.
As agreed by learned advocates of both the parties, recessal is the matter on Wednesday.
Yes. And Your Lordship, I also beg to mention item 32. Now, in item 32, I'm appearing in WPC 133 of 2025. Your Lordship, this is a single bench matter. This one, the first one is 133 of 2025.
Yes.
So if this matter can be delayed, and if this matter can be listed on Wednesday, on Monday, coming Monday, it's a single bench matter.
Okay. Item number 32.
32, just the first one now. Yes. 133 of 2025.
On the appeal being made by learned counsel for the petitioner, this matter is then segregated from the item number 33, civil revision number 5 of 2020, and be listed before the single bench.
No.
Single bench. And item number 33.
33, 34.
Item 33 is a division bench matter. Item 33, I'm not there.
Civil revision petitions are division bench matter.
Your Lordship, there is a reference has been made to the division bench. There are two conflicting judgments.
Okay.
A reference has been
Therefore,
made.
okay.
Yes.
Okay. Okay.
And in item 20, if I may, my lords, in items 24 to 29, there is an interim order that can be continued.
Okay. Interim order passed in item number so and so shall continue.
Much obliged.
There's an interim, the item number 32.
32.
Lord.
Okay. Interim order passed in item number 32 also continue.
I'd like to mention item number 33 to 36, Lord.
30?
33 to 36, Lord.
Yes.
This matter can come up after 2 weeks, Lord. Item number 33 to 36. In that case, after 3 weeks.
Okay. As agreed by learned advocates of both the parties, recess allays the matter. These matters after 3 weeks.
There's an interim in item number 36.
Interim order passed in item number 36 shall continue.
Lordship, I can beg to mention item number 58 to 60. Lordship, here the leading counsel Lima Wapang is on bail menu, Lordship. So if this matter can come up after 2 weeks.
58 to
Yes, 58 to 60.
60.
58 to 60.
Mr. Your name, please?
Medovero.
Medovero, learned counsel for the petitioner. Now for the appellant.
Lordship, I'm for the appellant, Lordship. I'm the appellant in item number 58 and 60.
Okay, state is the appellant. You are for the respondent.
Yes, in the 58 and 60.
Mr. Medovero, learned counsel appearing on behalf of Mr.
Lima Wapang.
Learned conducting counsel for the respondent number.
I'm for the appellant in item number 58, my lord.
59. Yes.
59.
59. Okay. Learned counsel for the conducting counsel for the petitioner. Price for listing the matter after 3 weeks.
Lordship.
After 3 weeks. Any objection? No objection.
Much obliged, Lordship.
Bear allowed.
Lordship, I beg to mention item number 61.
Yes.
Lordship, here, AG Advocate General will be leading this case, so I pray that the matter may be fixed on 25th of February, Your Lordship. I've taken the consent of the other side.
Okay. Item number 61, you are for respondent.
Yes, we are for the respondent, state respondent.
Respondent number?
State
Ms.
respondent,
So-and-so,
Lordship.
learned counsel appearing on behalf of the learned advocate general for the respondents with consent from the other side, price for listing the matter on 25th of February.
Yes, Lordship.
Okay. Fair allowed.
Lordship.
Mr. Lordships.
Yes,
Lordship, I beg to mention item number 63 from the supplementary proceedings, Your Lord.
62.
63, Your Lordship. Your Lordship.
I
this
mean, you have the full responder. Who are really allowed to file a job, the reason you can't do this. In the defects on the side of step in. You need it.
When can it be listed?
Your Lordship, this matter will be listed on coming Wednesday.
That is
Wednesday.
28.
Yes, Your Lord. As the leading counsel is in disposal.
Okay. Mr. Your name, please?
Jinjang Bong for Yanrawati CGC.
Learned counsel appearing on behalf of Mr.
Yanrawati CGC.
Learned CGC. With consent from the other side, press for listing the matter after
Next
no, on
28. On 28
28.
of January.
Okay. 28.
Much obliged.
Mr. Lordship. Lordship, I beg to mention item number 1, Your Lordship. Similar prior, as my senior is in disposal and if this matter could be listed on next Wednesday, Your Lordship. Yes.
Okay. On the pair being made by Mr.
Jinjang Bong,
Learned counsel appearing on behalf of Mr.
Yanrawati CGC for the
Learned
respondent number
CGC.
1.
With consent from the other side, press for listing the matter on next Wednesday
Well,
as the learned CGC is in dispose of.
yes, Your Lord.
Mr. Mauzamir, learned counsel for the respondent number 6 and 7, and you for respondent number 8 present. Rest shall list the matter on Wednesday.
Obliged. May I please, my lords. Lordship, I beg to mention item number 44, 45, 46 on behalf of Mr. Interim Song for state, Lordship. He has some difficulties, so can you grant 2 weeks time, Lordship?
40.
44, 45, and 46, Lordship.
Mr. Your name, please?
K. Angami.
K. Angami, learned government advocate. Appearing on behalf of Mr. M.T. Imsong, learned PP.
Additional age, Lordship.
Here it is mentioned as PP.
Yes, yes.
With consent from the other side, any objection?
Lordship, I'm appearing for respondent number 40, appellant in item number 45 and 46, Lordship.
Okay.
Lordship.
As for listing the matter
After 2 weeks, Lordship.
after 2 weeks. Fair allowed.
Like here.
Fair allowed.
Obliged, Lordship.
With Ms. Lordships, I beg to mention item number 2 on behalf of the leading counsel, Precious PP, who is in dispose.
Here the matter pertains to the payment by the insurance company to the hospitals, private hospitals. Now, Lordship, the government has spent a policy. I think.
Yes.
So now the insurance company, it's the insurance board. Now the insurance company is not paying the private hospital,
Yes.
despite of the services given by the private hospital. Lordship. And as per report, their amount due as of date, as per our record, Lordship, as per the department record is 7 crore 22,68,777. This amount is yet to be paid by the insurance company. Now there is an insurance for the financial year 24-25. Now where is this from? Now, in the last petition, the insurance company was directed to file an affidavit as to the number of claims they have cleared as of date, hospital-wise. They are yet to file an affidavit.
Lordship, however, we have filed one affidavit in compliance on 3rd December, Lordship. The state government is yet to reply on them because, Lordship, we have got some no-use certificate from certain hospitals. Again, those hospitals are showing in the portal of the NHA, which we have already closed and already we have got a no-use certificate. So we want the clarification from the government with respect to sudden crop up of around 2,000 more than 2,000 claims, Lordship.
Lordship, in this
So let
regard-
them file an affidavit seeking
in this
clarity.
regard, we have written to the private hospitals. Now, Lordship, there's a clear direction by this honorable court. By order dated 15/10/2025 and 12/11/2025. That the insurance company should in no way negotiate with the private hospital because that is against the policy. Now, what is happening is the private hospital has written to the insurance company that they should not come to negotiate. It was their own document. It was placed on record. And as per the policy, Lordship, they cannot, because we are implementing it, we pay the premium to the insurance company. So they cannot negotiate with the private hospital. Now, Lordship, on that Lordship, we have written to all the private hospitals to give a detail of any negotiation done by them. But the private hospital have not even responded to that question. Lordship, this is letter dated 16 December 2025. We have asked the hospital to give the report by 21/12/2025. None of the hospital have reported to the report.
Okay.
Now, Lordship, we kindly see the latest affidavit.
No, that's all right, but today we are not hearing the matter since the council is absent.
Next week, what?
Next week.
Lordship, till February 12, I am indisposed. Any date after February 12, Lordship, any date.
Lordship,
Any date after February 12. Lordship.
we are talking about 2024 financial year. Lordship, we are in 2026.
Lordship, I have some difficulty till February 12. Any date after February 12, Lordship, can be fixed, I come down.
No, can
But in
we,
the meantime, let them file this affidavit also. Reply to our affidavit. How come to 2020, more than 2,000 claims suddenly cropped up, even though we have closed the claims, even though we have got a no-use certificate from the hospital? Let them file an affidavit seeking clarity.
We have in our portal. Claim rejected by the AGI, the Future Generic Insurance Company, 2,630. Lordship, here is the case. They make the payment and they raise objection that there is a fraud. They should have detected the fraud in the first place. Then only they should pay. Now, after payment only they are raising that it's fraud. How can that be, Lordship? Is it possible? After you make the payment, then you say, no, there's a fraud. So we'll stop the other claims.
Lordship, this is not stopping the other claims. What happened, Lordship? We have pointed out
What is
that
stop-
these are the
no.
fraudulent claims. We have pointed out to the government. Government said, no, we are assuring you. You pay, thereafter we will recover. That is on record.
No.
They have
Today,
assured us.
today we are not hearing the matter. Oh,
Next day.
if possible, you come on next week,
Lordship,
on Wednesday.
Next Wednesday.
he can always join online, Lordship. It's possible. If he cannot come personally, since he's based in Gauhati, he can come online, Lordship.
28.
20?
No, 28 is not. 28 is Wednesday.
Wednesday, yes.
Wednesday, next Wednesday.
Fine, Lord.
Okay, Miss, your good name, please?
Menashino.
Learned counsel appearing on behalf of Mr.
Kejo-sama Kiki,
Learned conducting counsel for the petitioner.
for the petitioner.
Petitioner. With consent from the other side, press for listing the matter on next Wednesday. The pair having not been opposed by the other learned counsel for the respondents stands allowed. This is a list the matter on Wednesday.
Lord. Best, Lord.
Mr. Lordship, I'd like to mention item number 23. I feel this matter may be listed after a week, as my senior is unable to attend this matter today.
Item number 23.
23,
Miss, your name, please?
Dushi Jamir,
Learned counsel appearing on behalf of Mr. City Zomi.
Sydney Jamir.
Learned senior counsel for the petitioner with consent from the other side. Press for listing the matter after
A week.
a week.
There's an interim matter.
After a week. Yes. Why?
He's out of station today.
as the leading counsel, Mr. Siti Zomi, is out of station. There stands allowed. This is the matter after a week.
After,
Interim order passed earlier shall continue.
Your Lordship.
I place your lordships. Lordships, I beg to mention item 47, lordship. Lordship, I pray matter be listed after 2 weeks, lordship.
47.
My senior counsel is currently out of station, lordship.
Who is your senior counsel?
Ajo,
Okay. Mr. Your name, please.
V. Kosa, lordship.
Learned counsel appearing on behalf of Mr. Azo, learned conducting counsel for the appellant. With consent from the other side, press for listing the matter after
2 weeks, lordship.
after 2 weeks. Bear allowed.
Much obliged.
Please, Your Lordship.
Yes.
I beg to mention item 3 and 4. The leading counsel for the petitioner is out of station, so if it may be listed after 4 weeks.
Miss
Yuka Kokla,
learned counsel appearing on behalf of Mr.
Cynthia Anger.
learned conducting counsel for the appellant. With consent from the other side, press for listing the matter after
4 weeks.
4 weeks. Bear allowed.
Your Lordship, similar prayer for item number 43 and 49.
Forty.
43 and 49.
Okay. Same order.
Members, Lordship. Lordship, I beg to mention item number 5. On behalf of Moy Jen. Lordship, please do the receipt instruction, so if this matter will come up after 2 weeks.
After 2 weeks.
Lordship.
Here in this matter, in the last order, the senior advocate, government advocate was directed to place before this honorable court some instructions in the last order.
Mhm. But the counsel is absent today,
Lordship, please do the receipt instruction.
not yet received any instruction. Okay. Miss, your name, please.
Ichano.
Learned counsel appearing on behalf of Mr.
Moy Jen.
Learned counsel for the respondent number. For the respondents.
1
all
to
the-
4.
1 to 4. With consent from the other side, press for listing the matter after
2 weeks.
2 weeks. Bear allowed.
I blank.
May please, Your Lordships, I beg to mention item number 48. I pray that this matter may be listed after 2 weeks.
Miss,
P. Mubini Izum on behalf of my senior Joshua Shiki.
learned counsel appearing on behalf of Mr. Jasso Saki, learned conducting counsel for the appellant. With consent from the other side, press for listing the matter after
2 weeks.
2 weeks. Bear allowed.
Bless you. Mr. Lordship, if I may mention, item 52 to 55. It may be refixed next Wednesday.
52 to 50?
57, lordship.
57.
Lordship.
Yes. Miss, your name, please.
Yuka Kokla,
Learned counsel appearing on behalf of Mr.
Cynthia Anger.
Cynthia Anger, learned conducting counsel for the respondent number 1.
Respondent number 1.
Respondent number 1 with consent from the other side. Press for listing the matter after
Next week.
in the next week. Wednesday.
Yeah, 28.
Okay.
Yeah, please, lordship. Lordship, in item 56 and 57, I'm for the appellant, lordship.
Yes.
Item 56 and 57,
Okay.
I'm for the appellant.
Is a record is. SSL is the matter on next Wednesday.
Obliged, lord.
For admission, item number 6. May I plead your lordship?
May I please, Your Lordship? Your Lordship, on the last date,
your extension order was supposed to be filed in the, by way of affidavit. That is not being done. So your chief, let the matter come up next week so that in meantime they can file the affidavit, your lordship.
Who is supposed to produce the extension order?
Your lordship, the extension order actually was furnished to them also. No, so maybe there was
No,
some.
no,
confusion
the
because of the
direction
papers.
was,
I was also supposed to give your lordship.
why
Some
could not obtain it?
miscommunication, your lordship.
You are for the respondent.
Yes, your lordship.
Heard, mister?
Yeah, Lordship, I'm appearing on behalf of the petitioner, since considering the fact that it's a habeas corpus petition, and I have filed my petition on 18th September of last year, Your Lordship. It's more than 4 months now. So I pray to the Honorable Court the matter may be taken up to the Your Lordship, considering the nature of the case, since it's a habeas corpus petition.
No, this court is ready to hear the matter, but the CC is not ready to argue the matter.
Lordship, on last 3 occasions, this Honorable Court has given enough time, and till date, state has not filed their affidavit also.
There was an extension. We were also ready to hear on the materials that was placed on record, your lordship. However, your lordship, since there was no challenge to the extension order, your lordship, that's why this court gave a direction that on the next date, like they were supposed to file by way of affidavit.
No,
challenge.
whether the record is available.
Your record to your lordship is available, though they have not filed extension or challenging the extension order. Record
Your
is-
Lordship, regarding challenging of that extension order by way of additional affidavit, if the very foundation of the detaining authority is not as per the law, then definitely I don't need to challenge that extension order also. So I am not going to file any additional affidavit challenging that extension order, Your Lordship. Because the very basis, if the very first detention order is not as per the law, then every consequence order becomes invalid automatically. So I am not going to file my additional affidavit, Your Lordship. I'm challenging the very first detention as well as confirmation order of the detaining authority.
Okay. Are you ready to argue the matter?
Your lordship, I was of the impression that like we will take up the on next week with the Lord's permission, your lordship, since they have not filed affidavit. So
No, he is not going to challenge the extension order.
lordship, since like I was of that view that I could not able to prepare. Otherwise, to address.
So let it be at 2 o'clock.
Reports I have,
Today?
your lordship, we can take it up. It's okay now. Also.
Sure, making a mention on behalf of Young Body for respondent number 4, who is representing for a unit, Ministry of Finance, Your Lordship. So far, the matter is concerned, Your Lordship, the union does not have much more to say.
Yes.
So if this matter could be listed in the presence of my senior, Your Lordship, if this matter could be fixed on next Wednesday for a convenient, Your Lordship.
Next Wednesday.
Yes, Your Lordship.
No, that's all right, but this is habeas corpus matter.
Exactly.
Already several adjournments are granted. So argue the matter then. Yes.
Lordship.
The union has nothing to do with it. Yes, argue the matter.
Lordship, as this Honorable Court is also aware that this instant petition is pertaining to detention of the petitioner under PIT NDPS Act. Your Lordship, the prosecution history in short is that on 26/4/2025, with reference to suburban PS case GD number 6 of 2025, a team was formed by the OC suburban PS and instructed the complainant, that is UBSI Moalong Jujir of Special Branch INT, to lead the team along with SBN PS personnel with a direction to proceed to the place of to conduct the surveillance regarding this illegal trafficking of drugs. So accordingly, as per the prosecution story, they led an operation and they have planted a customer in order to buy drugs.
Judgment.
Yes, Your Lordship, in order to buy drugs from the alleged source. So accordingly, as per the version of the prosecution story, that planted customer, he had successfully purchased the drugs, and accordingly, my house was raided, where I was living as a rented. So, Your Honor, Accordingly, as per the version, as per paragraph 4, the following items were recovered. Page 7, Your Lordship, paragraph 4, page 7. So these were the items allegedly they have recovered from my rented house. So, Your Lordship, accordingly, there were, I was arrested, seizure memo and arrest memos were made. So the concerned detaining authority, they have proceeded for obtaining detaining order under fit NTPS against me. So accordingly, Your Lordship, paragraph 8, the Special Secretary to the Government of Nagaland, he has issued detention order under Section 3, subsection 1 of PIT NTPS Act. And later on, Your Lordship, as paragraph 9, I made a representation to the state government for revoking my detention order, but unfortunately, that has been declined by the detaining authority on the ground that there was no valid ground to revoke my detention order. In the meantime, the Chief Secretary to the Government of Nagaland confirmed my detention order and again ordered for 3 months further detention. So, Your Lordship, now I would like to draw the attention of my petition, that is page 15, Your Lordship, regarding the grounds on which I am challenging my detention order as well as confirmation order. First of all, Lordship, as per Section 3, subsection 2 of the PIT NTPS Act, it states that after the detention order, the detaining authorities is under duty bound to inform the central government regarding my detention within 10 days from the date of passing of the detention order. Your Lordship, in this case, there is no record to show that the detaining authority has complied with these mandatory provisions of the PIT NTPS Act. Secondly, Your Lordship, Section 9 of the PIT NTPS Act says that the detaining authority has to refer the matter before the advisory board within the prescribed period of 5 weeks. Again, Your Lordship, there is nothing on the record to say that even this mandatory provision of Section 9 Clause B of the PIT NTPS Act has been complied by the detaining authority. Then, Your Lordship, as I said, since I was residing in a rented house, and allegedly, as per the record of the case, those items were recovered from the staircase of the building where I was residing as a rented. So, Your Lordship, how can it be said that those drugs which were recovered allegedly from the staircase of the building, those drugs were belong to me? Otherwise, from physical possession, nothing was recovered from my possession. So, Your Lordship, on this basis, I pray to the Honorable Court that the detention order passed by the Special Secretary as well as the this confirmation order passed by the Chief Secretary may be revoked, Your Lordship.
Okay. Yes.
Your Lordship. Your Lordship, the grounds on which the petitioner is seeking for revocation of the detention is that, like, firstly, it has not been notified to the central government also, Your Lordship.
Pardon?
Central government, Your Lordship. In the grounds, Your Lordship, if you
Yes.
see the grounds
Yes.
of challenging for revocation of the detainee, Your Lordship, we can see that the first ground that he has taken is that, like, we have not actually intimated the central government within 10 days, Your Lordship. But that we have also, you can see my affidavit, para 8, Your Lordship, where I explained that, like, within
Para 8.
para 8, Your Lordship. Para 8 of my affidavit.
Yes.
Yeah, Your Lordship, we have, I have stated that, Your Lordship, we have forwarded to the central government Ministry of Finance by email on 35/2025 and by speed post by tracking ID number so and so on 26/2025. So it's within the limitation, your lordship, we have actually sent to the thing. That is the ground, the first ground that he has taken. The second ground that the petition has taken is that your lordship, he was already under judicial custody, your lordship. Your lordship, I have also explained that, your lordship, in my paragraph, your lordship. Yes, your lordship, paragraph 7, your lordship.
Yes.
Yes, your lordship, I have stated that, your lordship, it is clearly mentioned that any authority was in the knowledge that the detainee was in judicial custody. And if out on bail, kept alert, the detainee was indulged in the seeming of prejudicial activities, your lordship. That we have actually stated, your lordship. We
But
have
have you
already-
mentioned it in the order?
No, that confirmation order.
No, no. In the very first order?
In the first order, your lordship,
Is it page number 41?
yes,
Order dated 30th May 2025?
yes, your lordship.
Lordship.
Your lordship here, your lordship, in the order to your lordship, it's not, yes, yes, your lordship, in the order is not written, your lordship.
Not written.
Yes,
But if it is not in the order itself, can the ground be supplemented in the form of an affidavit?
your lordship, here, why I have, the grounds, while taking up the grounds for detention, your lordship, we have actually stated that, your lordship. Not in the confirmation order, your lordship, but on the grounds of detention, your lordship. So
Where it is to be
examine-
mentioned, is it in the order or in your affidavit?
In my affidavit as well, not in the confirmation order, yes, your lordship, I think it is not in the confirmation order.
No, but in fact, where it ought to have been mentioned, in the order or in the affidavit?
It's a lordship that thing, it's a lordship.
Okay.
Yeah, another ground that the petition has taken is on the ground of not properly being properly explained, your lordship, in the language he understands, your lordship. But
In
here,
which language you have explained?
Hindi and Nagamese, your lordship.
Hindi and Nagamese?
Yes, your lordship. And even before the advisory board.
No, you have furnished the ground of arrest to them.
Yes, your lordship.
That was in which language?
The report, your lordship.
In
It's
which
in English, your lordship, but it was explained, your lordship.
explain?
And he said that he.
But madam, do you know that another case was filed before the Supreme Court? It is criminal appeal number 4872 to 4873 of 2024, Murtaza Hussain Chaudhuri versus State of Nagaland and others.
Lordship.
You are aware of that decision of the Supreme Court?
Regarding.
The grounds are explained
Yes.
in Hindi language, but but it is in English language. But Supreme Court has not accepted the same.
Your lordship, that is my submission, your lordship. It is up to the judicious mind, your lordship. But I believe I am making my submission, your lordship, the court can record it and the court can use its judicious mind.
Yes. Any other point?
Your lordship. I think.
Okay. The record is available with you.
It's available here.
You furnish the record to the court master. Yes. You have anything to submit? Nothing.
Lordship,
Yes.
Lordship, as this honorable court has noted that in the first detention order, that is 30 May 2025, there is no mentioning about the fact that I was already under judicial custody. It has not been reflected in the same order, your lordship.
Okay. Heard Mr. P. Sorin, learned counsel for the petitioner, and Madam
Levika, Your Lordship.
Levika, learned
Government advocate.
government advocate for the state respondent. Argument concluded. Judgment reserved.
Lordship.
For admission, item number 7.
My please, Your Lordship. Your Lordship, here also, I think more or less same. However, Your Lordship, I received this file this morning only. My colleague has an emergency. So she has to walk out, Your Lordship, because of the medical emergencies. So the matter was engrossed to me this morning only. Otherwise, I think the records are here. So Your Lordship, it's up to the court. Otherwise, they are also supposed to file challenge the detention, extension of the detention.
Your Lordships, the basic order has already been challenged in the writ petition, and in my prayer section, I've prayed that the consequential order, which will come in the form of the extension order, may also be quashed. So in that case, it is my understanding that since the basic order is already challenged, I need not challenge the consequential order. That is my belief and understanding. Your Lordship, the basic challenge in this petition is language. Murtaza Hussain is what I'm relying. But because I'm a Hindi speaker, I studied only up to class 7. And except for the grounds of detention, all other documents were furnished to me in English, in a language that I do not understand. Secondly, Your Lordship, the rigors of Section 37 of the NDPS Act has been effectively implemented in my case. Why? Because my bail application twice before the special court and before a single bench of this honorable court has been rejected. Why? Because of the rigors of Section 37 of the NDPS Act. And secondly, that's on facts of the case. Even when it comes to the law, the law laid down in Huijam Kunang Jaun Singh lays down 3 conditions. If a detention is challenged, the detaining authority has to satisfy the court that firstly, he was aware that the detainee was under custody. Secondly, that he would likely be released on bail, and that after releasing on bail, he would like to continue with his prejudicial activities. In my case, Your Lordship, they have not applied their minds. It's just mere ipse dixit statement that after my release on bail, I would continue. Had they gone into the facts and records of the case, they would have come to know and realize that my bail has already been rejected twice. So Section 37 of the NDPS case has been effectively implemented in my case. And yes. And thirdly, Your Lordship, I do not have any past criminal antecedents. Division coordinated bench of this court in similar cases also for people who do not have past criminal antecedents cannot be preventively detained. Why? Because there would be no basis to show that I would be continuing with my prejudicial activities if I do not have any past criminal antecedents. So those are the 3 grounds. I'm pressing forward, Your Lordship. I'm also ready with some case laws, if Your Lordship would like to peruse them.
Yes.
First one is Afia Begum. The relevant portions are from para 14 to 18, Your Lordships. If I may be allowed to read, Your Lordships.
Paragraph number 14 to
18.
not necessary. We'll go through the same.
Yes, Your Lordship, then very well. And the second case would be Murtuza Hussein. The relevant paragraphs are para 11, 14, and 15. And the third case, Your Lordship, it's a coordinate bench decision passing. The relevant para would be para 11. Your Lordship.
In Murtaza Hussain Chaudhary, in which paragraph you have relied upon?
Para 11, 14, and 15. Your Lordship.
And in the next one?
In the WP Criminal 18 of 25, I'm relying on para 11.
Yes. Any
Lordship,
reply?
The records are here. As I have stated, Your Lordship, I was given this file only this morning. So basing on the records, Your Lordship, court can dispose of.
Heard, Mr.
Kohima, Your Lordship.
Learned counsel for the petitioner, and Madam Levika, learned government advocate for the
On
state.
behalf of Your Lordship, Inaholi.
Learned counsel appearing on behalf of
Inaholi.
learned government advocate for the state respondent. Argument concluded. Judgment reserved.
I'm obliged.
For admission, item number 8.
Your Lordship,
Yes.
I'll be appearing on behalf of some of the respondents. From item number 8 to 17. So I'll be filing my Bagala Nama in the course of the day.
Item number 8 to
No notice has been issued. Anyway, Lordship, here one aspect is that since this is intra-court appeal, they want to take notice instead of publishing in the local dailies. In the previous two, we have filed previous two writ petition on December 5. But due to bulkiness, we could not file. Although we filed on 10th, it could not come up, and only today it is coming up. So in the previous two writ petitions, the previous councils, they accepted notice on behalf of the
all the respondents.
respondents.
Okay.
So in this case also, that is going to be follow up, and I pray that in
All the matters may be take together.
yes, in the previous writ petition, I'm giving my lordships. I also saw time, and it was on 5th, it came up before the Honorable Chief Justice and his companion judge. And the matter was listed on 12th again. So that in the meantime, those who could accept on behalf of the respondents, they accepted the notice. And there happens, those who did not accept the notice were published in the newspaper, and we have filed it day before yesterday, newspaper publication for those respondents whose counsel did not appear. So in this matter also, Lordship, if Lordship will kindly, those who will accept the notice, they will appear before this honorable court. So the matter may be listed next week, because they may not want their names to be published in the newspaper.
Okay. So, Madam, you are appearing for all the respondents.
Not all the respondents, but some of the respondents in some of the petitions, actually, some of the appeals. Some of the private respondents, because there's so many writ appeals. So I'll be appearing in response number 8, I'll be appearing for 6, 8, 9, 10, 12, and 13.
Which one? Okay. Oh, wait. 8. 8.
6, 8, 9, 10, 12, and 13.
Can they submit it to us in a note sheet? Or we can note it down for acceptance of notice.
Okay,
I can do that.
you can give in writing to her. Today, we will admit the appeal.
Lordship. Let the matter come up on 28.
Lordship, notice has not been issued, this case.
No, today we will
Will
issue
issue.
notice.
There are so many private respondents here.
Yes, that's why.
That notice has to go to the other.
That's
Yes.
why.
Yes, definitely notice will go. Heard Ms. Z. Zimomi, learned counsel for the appellant. And also heard Miss, your name please,
Tishi Jamil.
learned counsel appearing on behalf of the respondent number
6. I'll provide it. 6, 8, 9, 10, 12, and 13.
6, 8,
9, 10, 12, and 13.
12 and 13. And you are
I'm for the same lordship.
for respondent number 1 and 1, 2 and 3. 1, 2, 3, 4. 1, 2, 3, 4.
Since.
1, 2, 3, 4. This intra-court appeal is directed against the judgment and order dated 12/11/2025 passed by the learned single judge in WPC number 189 of 2023. It is to be noted here that by the impugned judgment and order dated so the learned single judge has dismissed the writ petition. Dismissed the writ petition. Produce the memo of appeal and the grounds mentioned therein. But madam, you see here, the learned single judge has observed on the basis of one decision of the Supreme Court that you have no locus standi to file the writ petition.
No. That is because we have approached this honorable court lordship. If we go by this, had they been appointed legally, that is one aspect, lordship. But here it is, we have approached this honorable court only for advertisement of the post appointed through backdoor and for advertisement only, lordship.
No, that's
Now,
but first you have to show that you have the locus to file.
yes, that's why. The honorable.
You are praying for writ of certiorari, but unless you have the qualification for being appointed to such post, you cannot challenge the appointment of others.
I have the requisite qualification, lordship. We are net qualified candidates. And these respondents were appointed through backdoor without advertisement. So that is our only grievances before this honorable court. And we have approached this honorable court under Article 14 and 16 only, purely on that, for violation of that. Until and unless the posts are advertised, how will we appear, lordship, in a competitive exam, whether by the department or by the NPSC? At the time when we first filed this writ petition, there were about 42 who were holding sanction posts. Now, by now, it started way back in 2015, lordship. It was first, the PIL was first filed by an NGO. So that is where the locus of the NGO arose. So this honorable court give liberty to the petitioners to approach this honorable court again if they violate notification 16/6/2016. That is ban on contract appointment. Then the very next day they started the appointment the very next day. They placed before this honorable court on oath that they will no longer, the state will no longer appoint contract appointment. The next day itself, they started appointment. Now the locus of the NGO was questioned. So when the petitioner were given liberty, they roped in Nagaland public aspirants candidates, and we approached this honorable court. However, on 2 occasions on maintainability, it was dismissed because in the first writ petition, the account filed RTI for 2 years. It was taken to procure all the department, 32 department backdoor appointees, and 706 Class 1 and Class 2 gazetted posts were filed. However, unfortunately, they did not sought for appointment orders. So when only the data was placed before this honorable court, the honorable court said that without appointing, for challenging the appointment orders, Lordship. So after that, another writ petition was filed. Another writ petition was filed, and that was all the posts were filed together. This honorable court said to segregate the 32 departments separately and to file. So that was how maintainability, on issue of maintainability, it was to be segregated and to file. So after segregating, after that, and not to make any appointment thereafter on contract basis by in 2018, it was passed. The state went for appeal, and the appeal was dismissed. Now, Lordship, 32 departments, the petitioners are educated, unemployed youth, so they could not challenge the other 37 departments. But for this higher and technical education, they had a qualification, requisite qualification of net qualified, so they challenge their appointment without advertisement through backdoor. Then in the second writ appeal, again, this honorable court said to segregate subject-wise again. The previous one was to segregate department-wise, that was the direction. So the net qualified students, they segregate the subject-wise, and now this is the subject-wise writ petitions filed before this honorable court. Now, again, if Lordship will see the impugned judgment order, the learned single judge has said to each cause of action, only the date and year is different. Otherwise, it's a backdoor appointment without advertisement. The principles are all the same. The issues are all the same. Now, to file one here, if Lordship will go through the judgment order, to file separate writ petition as per the respondents, that is, it will amount to hundreds. It's more than 100, including those previous 2 filed. So that is one issue where maintainability, that is dismisses, to file separate writ petition as per the subject wise we have already filed. The third one. Now, that is one aspect.
Okay.
And the second aspect is that after more than 10 years, now the Locus standard, we say that we don't have the Locus standard that has been observed. Then again, we are asked to file again. Lordship, is that legally permissible? That is, apart from the merit of the case, the maintainability to file separate writ petition of each respondent is not mandated. Secondly, any backdoor appointment, Lordship, had they been appointed legally, that the issue of locus will come out. But backdoor appointment, any time which was done without advertisement, I have the locus standi, Lordship. That's why my locus has already been quashed. And in the near future, it will, not only in this case, but if we go through the judgment order, next, no qualified student will be able to challenge the backdoor appointment until and unless they have the qualification. And the opinion that we have to have a qualification at the time when that backdoor appointment was appointed.
So since that the time made the petition is this is there. What is peruse the memo of appeal and the grounds mentioned therein. And also peruse the impugned judgment and order dated 12/11/2025 passed by the learned single judge. Admit, issue notice to the respondents returnable in 4 weeks. However, no formal notice is required to be issued to the respondent number 1, 2, 3, 4, 6, 8, 9, 10, 12, and 13, as they are represented by their engaged counsel. However, step upon respondent number 5, 7, and 11 be taken by speed post with ADA.
Lordship, I humbly pray one, Lordship, just let this, in the meantime, within this week, we will know whether the respondents will accept the notice on behalf of the respondents. Let the matter be listed on 28th, so that if those who did not accept, we will file through paper publication. That is my humble prayer before the Honorable Court, Lordship, as in the previous case. Lordship, this is one that was passed by whether
Paper publication is permissible only when the other methods of effecting service of notice fail to yield any result.
that is one aspect.
In a routine manner, we cannot allow you to publish notice in the paper.
Lordship, here in the first two writ petition, the writ appeal was this much bulky, because of the bulkiness of the writ petitions. So that's why, Lordship, in consideration, that's why just if it is listed on 28, we will come to know whoever will accept notice by the previous advocates.
No,
So
that's
just
all right. Today we will pass the order. You no need to take any step upon them. Wait till 28.
Oh, Lordship, yes,
Pass the order.
yes, Lordship, that is my humble prayer.
Step upon the respondent numbers also be taken by registered post, speed post with ADN also by usual process within a week from today. Registrar take the WPC number so and so along with this writ appeal and list the matter on 28 along with WPC number, writ appeal number.
Previous ones?
Yes.
Previous ones are fixed on 11/2/2026 because of service notice through public newspaper publication. The two writ petition, the previous one, when it came up on 5th, it has been fixed on 11/2/2026.
Then let it be on 11.
Lordship, I pray that because of the
Let it be take with those two writ appeals.
Yes,
Similar
those
subject
who
matter.
appeals, those who accept the notice,
Yeah.
they're already over. Those who did not, paper publication was taken from Lodge. So if it is followed, I humbly pray, because of the bulkiness of all the writ petition, it will be, as I have pleaded before this honorable court, the respondents are educated and employed.
That's all right. But all the matters are to be here together,
Yes.
to be heard together.
Yes, that's why let the matter be fixed on 28, and if those who accept notice, that is, that will be it, and on 28, those who did not accept by the council, they can be paper publication as in the previous proceeding may be allowed. I humbly pray, Lordship. That is my humble prayer. Let the matter be just 1 week. Give the petitioners appellants 1 week. These are the
No, what are the matters fixed on 28?
No, those two are fixed on 28. It can be fixed along with the two petitions. It is fixed on 11/2/2026. So on 28, after clarity of the service notice that is to be accepted, whether by the council or so, on 28, Lordship can just give a direction.
Okay. On the pair being made by learned counsel for the appellant, recessal lays the matter on 28. Along with, on that day, no other writ appeals are fixed.
No, other, only this 11.
Okay.
All the writ petitions, Lordship, that is, it's analogous like 8 to 18.
They're same.
Same analogous.
Same order is.
Same order. Only the subject is different. Segregated.
Respondents are also same.
Same. Everything is the same.
Okay.
Oh, different respondents. So on 28, it can be taken care of.
Different respondent.
Yes, only different respondents.
But then in that case, you give the list of respondents you were representing.
Yes.
To the private secretary, so that we can reflect it in other orders.
Lodge. Obliged, Lodge.
For orders, item number 20.
9, 8, 9, 10.
Till 18.
For admission, item number 19.
Yes.
Your Honours, we are the appealants in item number 19. We are challenging the order passed by the single bench, order dated 19/12/2025, which violates the constitutional right to life of our critically ill child that is currently on life support. We request the court to urgently pass a stay on the impugned order in order to protect the life of the child until the matter of the writ appeal is heard and adjudicated on.
Now the child is taking treatment in which hospital?
In respondent number 1's hospital, Your Honour.
Anybody for the state respondents?
They have not served us a copy. They have not served us a copy of the appeal.
Your Honour, if the appeal is accepted by the court, we can provide.
No, before that, they have to serve us a copy.
Before.
Otherwise, how
Your Honour,
do
we can
know?
provide it today. Since it's an urgent matter, as the 30-day deadline that the impugned order has imposed
No, when the 30 days will expire.
It has already expired, Your Honor, on
Already
Sunday.
expired.
On Sunday, it has expired. So now that it has expired, the life of the baby is directly at stake because the order is passing a 30-day limit in which we, the petitioners, the appellants in this case.
Maybe, but still the respondent number one has been providing treatment to your baby.
We have submitted a letter requesting that despite the impugned order, allowing for discontinuation, that they may humbly continue to provide.
Lordship, if you see,
They are not under obligation.
Lordship, if you see the judgment is very clear, saying that till 30 days, the respondent number one has to look after the baby. And after that, if the petitioner wants to continue the treatment with the hospital, they have to pay the bill, Lordship. Yes. So now, there is nothing illegality in the impugned order which they are challenging, Your Lordship. It's a fair judgment, Your Lordship.
Your Honors, I completely disagree with that. Throughout the proceedings, from the writ petition was filed originally to do with the allegations of medical negligence and for the state intervention to uphold its, for the state to uphold its legal duty to provide care in the government facility. Now, throughout the proceedings, the court did pass an order. Your Honor, if you just give me time. Order dated 18/2/2022 in WPC. In the writ petition, 18/2/2022 in the writ petition, the court upheld the principle that the right to life under Article 21 extends to the right to uninterrupted medical care. So the order was very detailed. The order is in the impugned order itself.
But madam, you have to serve a copy of this writ appeal
Yes,
to
Your
the
Honor.
counsel for the respondents well in advance so that they can also obtain instruction.
Your Honor,
Yeah,
the
you
court
have-
was on vacation, so it was we had only 3 days to finalize all the filing. But we are more than willing, yes, to comply and provide copies to all the parties. But the most important today itself is the IA 6/2026, because the 30 days have passed.
No, that's all right. But without hearing the other side, it would not be proper for this court to pass any interim order.
Your Honor, if
Till passing any order in the interlocutory application, we will direct the respondent number one to continue with the treatment of your baby.
yes,
Your
Your
Lordship,
Honor.
that would create more complications, Your Lordship. See, if Your Lordship see the judgment at the direction number 8, it's very clear, Your Lordship. The judgment, it says, it is also the opinion of this court that some caution time be granted to the petitioner because respondents number one have been treating the baby without payment from the petitioner for the last about 5 years, Your Lordship.
That's
5
not
years.
correct, Your Honor.
So some
We
caution
have paid in full.
should be granted to the petitioner to make alternative arrangement. Accordingly, this court grants the petitioner a period of 30 days from today to make necessary alternative arrangement to continue with the treatment of the child, either at respondent number one hospital or other hospital. The respondent number one shall continue to provide the treatment presently administered to the petitioner child for a period of 30 days from today. And thereupon, if the petitioner wish to continue the treatment of the child at the respondent number one hospital, the same shall be subject to the payment of the dues as per the terms and conditions of respondent number one hospital. So
No,
the dues has come to more
that's
than
all right.
Your Lordship.
Today we will not pass any interim order.
Yeah, no interim order, Your Lordship,
But
yes.
the treatment has to be continued in the
I think it
by
has
the
been
respondent.
continued. Otherwise,
till disposal of the IA interlocutory application.
Your Honor,
That too, Your Lordship, I'm not for the hospital, so I cannot
No,
say
you may
anything
not,
on
you
that.
may not be for the hospital, but interest of the baby is the paramount consideration of this
Baby is
court.
interest also, but Lordship, it is the responsibility of the parents also, Your Lordship. They cannot shift everything on the burden of the state or the hospital. The payment has crossed more than, on the last occasion, it has crossed more than 1 crore, Lordship, and the hospital were not in a position. So taking into consideration everything, the Lord Justice Davashis has taken everything, Your Lordship, and it is a fair judgment, Your Lordship. If at all the petitioner are aggrieved, they are supposed to approach the appropriate forum without medical negligence. How can the burden be shifted to the hospital? That's a
No, no,
question,
today we
Lordship.
are not hearing on the merit of the
True,
matter.
Lordship, yes. Since I'm only for the state, Your Lordship, on the hospital, I'm just only giving a brief idea on.
No, that's all right.
Yes.
All right.
30 days expired. Have you made any payment?
Yes, for that one also they have to make the leave.
Have you made any payment?
Your Honor, we have paid in full.
Even some amount, huh?
We have paid in full admission, excuse me.
Within this 30 days,
Madam
within this 30
Legacy.
days after passing of this judgment, have you made any payment?
30 days we have not. As the court is well aware throughout the orders and proceedings of the case, we have exhausted all of our savings, we have exhausted our finance. We were not able to shift the baby to a government facility, which would be much cheaper, because as it's in the record, Your Honors, that there was an inquiry to see whether there was any hospital able to provide the treatment. There was found that no hospital in the state, and actually till date, there is no hospital in the state, and the state has admitted to such, that can give the proper care, life support that the child needs. Now, the court did try to shift the baby to Ames, Delhi, but airlifting, as per Ames advice and the the Indian Army's advice, is that it's due to the condition of the child is dangerous to airlift. So only ground transferring would be safe. But at the time, the whole of the Northeast, as the record shows, had no hospital that can provide the proper care. Now, if we cannot take our child to the government hospital because there isn't one available and we cannot afford to pay the outstanding bill, this order pretty much sentences the baby to lose her life.
No, that's all right. But the thing is that if they are not in a position to make any payment, then what to do?
As per the judgment, the father took leads to the on payment. It appears. It is from. With me, will continue. Can it be?
No, first time, what is said, one thing. We admit this event, we will not stay the order. But we will direct the respondent number 1. Continue with the treatment this way. Uninterrupted care.
Probably they may not that the admission also will be possible in this case. This probably will be dismissed at many cases. But in that field, so
No, you see this. Unless admit the appeal, we cannot direct the respondent number 1 to continue with the case. Okay. Unless we admit it. Okay. Later we will see if it is not a case for admission, then later it will see. Okay. No, the camera was the number. It must be but the 30 was already in. But respondent number 1 refused to provide treatment. So, madam, you serve copies of the writ appeal?
Yes, Your Honor.
To all the respondents?
Yes, Your Honor.
And thereafter we'll hear the matter.
Your Honor, I have
Today,
a request.
we will pass order. We will admit the appeal today.
Yes, Your Honor.
And we will also pass direction to the respondent number 1 to continue with the treatment until further order.
Thank you,
That
Your
is
Honor.
this disposal of the IA.
Thank you, Your Honor.
At least, Lordship. In this case, my senior was the counsel for the hospital, Your Lordship.
Yes.
Local counsel. So, Lordship, I believe that since they are here, Lordship, their baby must be being taken care by the hospital.
Pardon?
I believe that the baby is still being taken care by the hospital, my lord.
Yes.
So, no such order may be passed, Lordship.
Pardon?
Since the petitioners are here before this local court, filing this writ appeal, I believe that the baby must be still under the care of the hospital, Lordship. So, no such order may be passed, Lord.
Lordship,
Your
one
Honor, I completely disagree.
complication is that, Your Lordship, since the IA which they filed to continue the treatment, we have not seen the IA, but I think that must be the prayer. So,
No,
Lordship,
IA is for staying the impugned order.
stay for the impugned judgment. Lordship, then in that case, Lordship, unless that one is stay, a direction may be given to the hospital to continue with the treatment, but for each day, the petitioner has to pay for the bill. For that, after
No,
the
that will
expiry
be
of the
determined later on. Today we are not hearing the matter.
Otherwise, Your Lordship, there is no ground for appeal also. They have been given opportunity
No, madam,
to
you
approach
see,
any court, Lordship.
the 30 days time already expired.
Expired, Lordship, yes.
And if the respondent number 1 refuse to provide treatment to
No,
them,
no,
what,
no.
what would happen?
No, they have to approach the respondent number, as per the order, they have to approach the respondent number 1 to continue with the treatment. So if the respondent number 1 agrees, then they have to pay the bill for after the expiry, they have to pay the bill, Your Lordship. But for the pending bills that have to be taken care, they have to approach the Consumer Forum for medical negligence, Your Lordship. Because the main ground of filing this appeal is that for medical negligence, Your Lordship. Yes. Because now even the pending bills has come up to more than 1 crore 50 plus, Lordship. That's what last time the court has shown. And the petitioner is saying that they are not in a position to pay. They don't have any sufficient amount. So last time my AG appeared in this case. Even my AG also submit to the court that in that case, the petitioner has to file the assets, Your Lordship, so that it is shown that they have no means to look after the baby, Your Lordship.
And we did respond
Because
saying
in
that
the
we were
affidavit-
willing, Your Honor.
Lordship, in the
We can
affidavit,
submit
everything
anything
in
that
the
we want to.
hospital also clearly says that the petitioner they have sufficient amounts in foreign currency, Your Lordship, in the bank account.
No
And the
evidence has been
affidavit
provided
was
to the court of
filed
such,
by
and
the
we have
hospital.
explicitly stated that we're more than willing to
Granted,
provide
this
everything,
there
bank
will
account,
create
everything.
more complication. We do
No, no,
concern
no,
for the
no.
entire Lordship.
We are not inclined to pass any interim order today. But this treatment has to continue.
Okay, till such time the
Yes, yes.
Lordship. Okay. If that's the case.
Heart, miss, your good name, please.
Your Honor, my name is Barbara Nunes.
A learned appellant petitioner. And also heart, Miss
Vishukri, Your Lordship.
Sukari, learned additional AZ,
Your Lordship.
additional AZ, and Mr.
Medovero,
Medovero, learned counsel appearing on behalf of
respondent number 1.
respondent number 1. Respondent number 1. This intra-court appeal is directed against the judgment and order dated 19/12/2025, passed by the learned single judge in WPC number 6 of 2022. It is to be noted here that by interim judgment and order dated so and so, the learned single judge has disposed of the writ petition number 6 of 2022 with the following direction. with the following observations and directions. Page number 46 of the impugned judgment. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, and 12. Where is the memo of appeal and the grounds mentioned therein? Admit. Issue notice to the respondents. Returnable in 4 weeks. However, no formal notice is required to be issued to the respondent number. You may accept the notice. Since Mr. Medu Vero, learned counsel, appearing on behalf of Mr.
Lordship,
You were appearing on behalf of Mr.
POCSO 48, Lordship.
Learned counsel for the respondent number 1, and V. Sukeri, learned additional lazy.
I'm for respondent
For the-
number 3 and 4, Lordship.
Respondent number 2 and 4 entered appearance and received notice. However, extra requisite copy of the appeal be furnished to them during the course of the day. Step upon respondent number 3, 5, and 6 be taken by speed post with AD and also by usual process within a week from today. Rest shall take the WPC number 6 of 2022 with this writ appeal. Aye. Lays the matter after 4 weeks. In IA number 6 of 2026, you take down. Hard, Ms. So learned. Appellant in person. And also hard so. This interlocutory application is preferred by the appellant. For staying the impugned judgment and order dated 19/12/2025, passed by the learned single judge in WPC number 6 of 2022. The learned counsel, learned appellant petitioner, appellant in person submits that the impugned judgment and order is required to be stayed as while impugned judgment and order only 30 days time was granted to the respondent number 1 to provide treatment to the ailing child of the appellant, and unless the impugned judgment and order is stayed, the respondent number 1 and other respondents may refuse to provide care and support to the medical care and support to the petitioner, to the appellant's child, and as such the right of the child and the appellant would be violated, and as such it is contended to stay the impugned judgment and order passed by the learned single judge. But having heard the submission of learned appellant in person and also the counsel for the respondent number so and so. This court is of the view that further hearing on the point of staying the impugned judgment and award is necessary. When the impugned judgment and order is necessary, is found to be necessary, and as such, it is provided that recess shall list the matter on next Wednesday. Can you make it convenient to remain present on next Wednesday?
Yes, Your Honor.
Wednesday. In the meantime, a copy of the interlocutory application be furnished to the learned counsel for the respondents, and till disposal of this interlocutory application, the respondent number 1 shall continue with life supporting medical care and financial support to the appellant's minor child, and also ensure that the child receives uninterrupted care in the said hospital. List the matter on next Wednesday.
Thank you, Your Honors.
For orders, item number 20.
Please take 5 minutes. Okay. After this.
After this.
Wait, please, Lordships. Lordships, by order dated 10/12/2025, I was allowed to file an application and pleading respondent number 2, Lordship, the mother of the victim, Lordship. Since this is an appeal through the Legal Services Authority, I have to communicate it to the authority, Lordship, to get the proper information as to the address of the victim's mother, Lordship. Now I have received the instruction just recently, if I may be allowed, further a week's time to file the application for implement of respondent number 2.
Heard, Mr.
Moa Jamil, Lordship.
Moa Zamir, learned counsel for the appellant, and Ms. Levika, learned PP.
Yes.
For the state respondent. Mr. Zamir submits that within a week,
Yes, Lord.
he will file impleadment petition for bringing on record the legal representative of respondent number 2, and he has already received a list of
the
legal
Yes, Lord.
representative of the respondent number 2, and he pressed for granting him 1 week time. Where is accordingly allowed. Rest is always the matter after 1 week.
1 week, Lordship.
After
Month by month.
we'll take it back.
Yes, Lordship.
For orders, item number 21.
May I plead your lordship?
Yes.
Lordship, I have the instruction to appear on behalf of the leading counsel, Mr. N.K. Muri. Lordship, he has told me that he is in his native village and there is a network problem. So he has instructed me to appear on his behalf, and he asked me to adjourn the matter and to list the matter after 4 weeks, your lordship.
Okay. Mr. P. Surin, learned counsel, appearing on behalf of Mr. N.K. Muri, learned conducting counsel for the petitioner. Press for listing the matter after 4 weeks. After 4 weeks.
Lordship.
Mr. Angami, any objection? Submits that he has no objection. Accordingly, taking note of the submission of learned counsel. for
Chief
both
Practice
the part-
objection, he just smiled.
It is provided that registrar shall list the matter on after 4 weeks.
Lordship.
For orders, item number 22.
I'll be very, on behalf of this, private respondent.
Private respondent number 6.
I'm mentioning on behalf of Sir Lucky. I'm mentioning on behalf of Lucky J. Lucky J. His name is not reflected, so I'll be writing my locality.
You are?
I'm appearing on behalf of Lucky J.
Mm.
He's out of station today,
Oh.
so we will be appearing on behalf of private respondent number 5. So the.
5 or 6?
6. 6, respondent number 6.
6. Heard, Mr. Learned counsel for the appellant. And Miss Learned counsel appearing on behalf of Mr. What is Jamir? Learned conducting counsel for the respondent number 6. Submits that Mr. Zamir is out of station, and as such the matter may be listed after a week.
Can be listed for hearing since this appeal has been admitted on 3rd of September 2025.
Okay. After 1 week.
Good.
After 1 week. The learned counsel for the petition appellant submits that the matter may be listed for hearing as all the parties are represented by the engaged counsel. Accordingly, it is provided that registrar shall list the matter on after a week. 28. Okay. Okay. Whether the other respondents are represented by the counsel. Okay.
For orders, item numbers 30 and 31.
Please, Your Lordship. Your Lordship, on the last occasion, the court has given a direction for constitution of the board. Your Lordship, I am informed that the board is already constituted. Lordship, however, I am yet to receive the copy. So if the matter will come up next week, so that I will request that the report of the constitution of the board.
Heard, Mr. Learned counsel for the applicant. In IA 39 of 2025, an appellant in criminal appeal jail number 12 of 2025, and Ms. Levika, learned government or learned PP for the state respondent. Ms. Levika submits that she was directed by this court to obtain the report of the board.
So it's a direction for constitution of the board.
No, submits that there was a direction of this court to constitute a medical board to examine the health condition of the appellant. And to that effect, one board has been constituted, and
Need to receive that.
and she has not yet received a report from the board. And as such, she prays for listing the matter after
Next week.
next week. Pair allowed, registrar list the matter on 28. 28.
For orders, item number 37.
Here, the service of the above so I will be allowed to select trustee service.
Okay. Miss, your name, please? Learned Counsel for the applicant in IN number 181 of 2025 submits that service of notice upon respondent number 2. The service report in respect of respondent number 2 is still awaited, and she prays for according her permission to effect service upon respondent number 2 by Dastimut. Pair allowed. After effecting service upon the respondent number 2 by Dastimut, she shall file an affidavit before this court. Registrar list the matter after 4 weeks? 2 weeks. After 2 weeks.
For orders, item number 38.
It's,
Respondent number 5
yes, still awaited.
still awaited. What to do? You want to take fresh step?
Okay.
Or Mr. I'm Jamir, Learned Counsel for the petitioner, and Ms. Levika, Learned PP for the state respondent. Learned Counsel appearing on behalf of Mr. Learned Additional Lazy.
Yes.
Office note dated 28/1/2026 indicates that service report upon respondent number 5 is still awaited. The Learned Counsel for the petitioner submits that he may be allowed to take fresh step upon respondent number 5. Pair allowed. Step be taken upon respondent number 5 by speed post and also by usual process within a week from today. This is a list the matter after 4 weeks.
For orders, item number 39.
May it please your lordship. Lordship, this honorable court was pleased to issue notice in the IA in the condemnation petition to respondent number 1. However, my lord, the service are still being awaited. So, my lord, it's a NHI DCL. On 1911, the notice was issued, my lord. And the service is still being awaited, my lord. So, I may be allowed to take steps through, my lord, email ID, because an arbitration proceeding has already been going on against the opposite party. So, I may be allowed to take steps through email ID upon the NHI DCL as it's a union body, my lord. My lord, order of the arbitral proceeding has already been there, my lord. The local council would have had it over, my lord. They have already been notified that the case is pending.
Heard, Mr.
SP Sharma, my lord.
SP?
Sharma, my lord.
SP Sharma, Learned Counsel for the applicant. Mr. Sharma submits that service report in respect of respondent number 1 is still awaited. And he submits that he may be allowed to take step upon the respondent number 1 by email.
Email ID, man.
But whether such a provision is there in the rule?
My lord, my lord, as per the Guwahati High Court rules, applying the appeal of 226, the division bench has the power, my lord. In fact, in many of the cases in the principal seat, it has been allowed through email and through WhatsApp services, my lord. My lord, in fact,
WhatsApp service that was not accepted by the Supreme Court.
yes, but the email ID was, my lord. The email ID was accepted, my lord. In fact, my lord, I would like to, there's an order that's before my lord. Then arbitration proceeding has already been going on. And in that, the opposite party has already been, we have already communicated to the opposite party. May I read, my lord, the order? If my lord pleases.
Not necessary.
Yes, my lord.
Accordingly, taking note of the submission of learned counsel for the applicant.
Address your date. Address your date. Represent, right? And constitution. Yeah. No longer in the same.
Left address. Okay. You modified the order. Office note dated 15/1/2026 indicates that though notice was issued to the respondent number 1 by speed post, the same returned with a report that with a remark that with an inverted comma left address. The learned counsel for the applicant, however, submits that he may be allowed to send notice to the respondent by email. Where allowed, step be taken within 2 working days from today. Recess the matter after 2 weeks.
4 weeks, my lord. I've been led by Mr. P.K. Tiwari, my lord. So the convenient.
4 weeks.
May I pray for a fixed date on a Wednesday on the February end, man? Like we'll be traveling, counsel. So, my lord, a deepest request, my lord.
When can it be fixed?
On the last Wednesday of the February, my lord.
Okay, on 25th of February.
My lord, much obliged, my lord. Much obliged, my lord.
For orders, item number 40.
The idea alone remains we can put them together and we can just for sharing the process.
This is for what purpose?
For the call of an order previously passed. But in order to dispose it, I have to meet the entire submissions on the rights of the cases. I have filed the IAS a matter of abundant caution.
Okay.
So if the matters can put them together and it is for hearing the due process.
This appeal is already admitted?
Yes.
The respondent accept notice. Respondent accept notice since I said no. In the eye and then mix together.
Okay. The matter is ready for hearing.
Yes.
Okay. Okay. Heard, Mr.
Thank you, Lord.
Learned counsel for the appellant and Mr. It is submitted at the bar that the matter is ready for hearing and this matter along with I number 249 of 2025 may be fixed for hearing on a date to be fixed by the registry after.
That's because of the registry.
Okay.
For orders, item number 41.
State of Nagaland.
Let's see if my colleague has filed this, so let's check if what can come out weeks.
After 2 weeks. Ms. Levika, Learned Counsel, appearing on behalf of Learned Government Advocate. Price for listing the matter after 2 weeks. After 2 weeks. Parallel, recess the matter after 2 weeks.
For orders, item number 42.
Your Lordship, please praise that, if your Lordship may be pleased to condone the delay and issue notice.
This I is for condonation of delay. For how many days?
Yes.
18 days. Any objection? What is the ground?
Accomplishment on
No. Oh, why the appeal could not be filed in time? Why? You have explained it in which paragraph of your application? You have not gone through the same. You have the file is also not available with you. Heard, Miss? Learned Counsel for the applicant, and also heard Miss Levika, Learned Government Advocate,
On behalf of Ilaholi.
appearing on behalf of Miss Inaholi,
Yes.
Learned Government Advocate for the state respondent. This interlocutory application under Section 5 of the Limitation Act is preferred by the applicant for condonation of delay of 18 days in filing accompanying appeal. The Learned Counsel for the applicant submits that the appeal could not be filed in time. Yes. She could not obtain legal advice in time, and that the delay is not intentional, rather it is circumstantial, and the same has been explained in paragraph number 3 of the application. And under such circumstances, it is contended that the delay may be condoned and the appeal may be admitted for hearing. Ms. Levika submits that she has no objection in the event of condoning delay of 18 days in preferring the accompanying appeal. Having heard the submission of Learned Counsel for both the parties, we have carefully gone to the application and the grounds mentioned therein, and it appears that the delay of 18 days is sufficiently explained. And accordingly the same is stands condoned. In terms of above, this IA stands disposed of. In view of the order passed in the IA, SSL register the appeal and list the same before this court on next Wednesday. But it appears that before the delay is condoned, the appeal has been registered.
Already numbered.
It's not the practice. No. Only after consideration of delay.
And unless delay is created. We have been practicing that. So that should not be actually.
That should not be. Only when the delay is condoned, only then appeal has to be registered.
If the delay is dismissed, then you have to register.
Okay, we will consider it on next Wednesday.
From the supplementary cost list for orders, item number 62.
I number 26.
Delay of how many days?
91 days. What is the reasons? A patient of 10 and 11.
This is a POCSO case.
Yes, Lord.
So notice has to go to the respondent number 2. You are for the respondent number 1. Heard Mr. Madhuhero, learned counsel for the applicant, and also heard Mr. Angami for respondent number 1, learned PP for the respondent number 1. This interlocutory application under section 5 of the Limitation Act is preferred by the applicant stroke appellant for condonation of delay of 991 days in preferring connected appeal against the judgment and order dated 28/7/2023, passed in GR case number 347 of 2021 by the learned special judge, fast track special court POCSO, Dimapur. Full stop. It is to be noted here that by the impugned judgment and order dated so and so, the learned trial court has convicted the applicant stroke appellant and sentenced him to suffer rigorous imprisonment for 20 years and also to pay a fine of rupees 20,000 under section 376 within bracket 3 IPC read with section 4 of the Protection of Children from Sexual Offences Act 2012 with default stipulation. Let notice be issued to the respondent number 2 by registered post through the office of the PP. What is the practice here? In principle, it is through the office of the PP.
Yes. Through the registry.
Registry will send it to your office. Okay. Through the registry of this court. Registry of this court. List the matter after. 4 weeks. After 4 weeks.
For hearing, item numbers 50 and 51.
Please, my lord.
My lords, I beg to appear in the matter, my lords.
Yes.
My lords, we appear in item number 50. We are for the appellants in item number 50. And Mr. Manish Singh appears in item number 51, my lord, for the appellants.
Yes.
Yes, my lord. May I just give a short, my lords, summary of this case, my lord?
Okay.
My lords, what had happened was there was a a government of India, my lords, direction, not government of India, but the Food Safety and Standards Authority of India.
Yes.
My lords, what happens is that, my lords, in order to ensure safety and to maintain requisite standards, we have a act called Food Safety and Standard Authority Act, my lords, under which there is a Food Safety and Standard Authority of India. And, my lords, under the provisions of the act, they can issue directions to the state governments, which is binding on them, binding on the state government. Therefore, my lords, on 6th of August 2014, they issued a direction that apart from the regulations which permit, my lords, meat consumption and, my lords, the standards to be maintained for the purposes of packing of the meat and, my lords, slaughtering of the animals, all other animals are not to be slaughtered. That is of 6th of August 2014. So, my lords, we have a regulations which are framed by the Union of India, which state that under what conditions and which conditions the particular, my lords, this is known as, my lords, Food Safety and Standards Act of 2000, and there are regulations which are made thereunder, my lords. What had happened was that since 2014, which had banned slaughter of any other animal or any other, my lords, creature other than which is described or prescribed under the act, there will be no slaughtering. On, my lords, July 2020, 4th July 2020, which is the impugned notification before the learned single judge, the, my lords, government of Nagaland decided, my lords, that this directive which was issued by the government, by the Food and Safety Act under section 16 subclause 5 of the Food and Safety Act has to be implemented. Therefore, my lord, they said ban on import and sale of dog meat in the state. My lord, in my petition as page 51, item 51, it is at page 1, my lords, it is at page 75, annexure 3. Now, this is the impugned notification. Now, may I read that notification, my lord?
Page number 51.
Yes, my lords, I am appearing in my writ appeal number 12 of 2024.
Yes.
Akhil Bharat Krushi Go Seva Sangh versus, my lords.
Yes.
And, my lords, on 4th of July 2020, Government of Nagaland issued a notification.
You are referring to page number?
My lords, 77 is the paper in my paper book, my lord, 77.
Yes, 77, yes.
My lords, it acts as Government of Nagaland, Office of Chief Secretary, Nagaland, Kohima.
Yes.
Ban on import and sale of dog meat in the state.
Yes.
Whereas the central government Ministry of Health and Family has enacted the Food and Safety Act 2006 for the and Food and Safety Regulations of 2011.
Yes.
To regulate the safety of good food articles safe for human consumption. And whereas Regulation 2.5.1 of a FCCI regulation, meat and meat products, and as per 22.5.1 regulation, animal meals and animal belonging to any of the species mentioned below. Ovines, caprines, salines, bovines, and includes poultry and fish. Later on, my lords, even rabbit was included, my lords. And whereas the slaughtering of any other species, now this is most important, other than the ones listed in sub-regulation of 12.5.1 of the regulation is not permissible under the FCC Act and regulation. It will cover, my lords, the species which can be, my lords, slaughtered for the purpose of meat and meat consumption, and standards which have to be maintained is defined. They are ovines, caprines, salines, bovines, and, my lords, poultry and fish. Later on, rabbit was also included. Any other species is banned. Now, my lords, and whereas for the strict compliance of FSS Act and regulation in order to regulate the safety of food articles safe for human consumption, it is necessary to ban slaughter and sale of dog meat in the state of Nagaland. My lords, my lord, dog meat has been also banned in other countries like, my lords, Philippines and South Korea, etc., my lords. Now, therefore, in consonance with the provisions of XFA Act regulation, the following are banned with immediate effect: commercial import and trading of dog and dog markets, commercial sale of dog meat in the markets and dine-in restaurants. And my lord, this is how, my lords, they have said that if any violation is there, then it will be punished under the Indian Penal Code and Prevention of Cruelty Act. And my lords, it has not informed. Now, this, my lords, what happens is that we have a regime called Food Safety and Standard Authority of India, which defines which animals or which creatures can be slaughtered and how they are to be slaughtered, how their meats have to be, my lords, packed, consumed, etc., my lords. This is a whole regimen, this is a comprehensive code. So any other species which is outside it also needs to be banned, is what they say. And if you want to slaughter any animal, then you have to fall in that 5 categories, which are mentioned just now. I have read, my lords: ovines, caprines, salines, and bovines, and poultry and fish and rabbit. Now, my lords, what happens is, now this is as this notification, which was in pursuant to the early directions issued by the Union of India or the Food Safety and Authority of India, has been assailed before the Honorable High in the present High in the High Court, my lords, by filing a substantive writ petition. And this notification has been quashed with the order dated 2/6/2023, which is the impugned order before my lords.
Yes.
And my lords, it has been, my lords, primarily quashed. My lords, kindly see at page, my lords, page number internal page 21 of the impugned order, para 25. Well, this is the argument which is placed. The learned counsel also submits that the Chief Secretary has a constitutional duty to ensure that the public safety and well-being of a citizen has full authority to issue the impugned notification. Since the consumption of dog meat is against the interest of health of the people, various scientific research papers state that dog meat endangers the human population.
Where are you reading?
Para 25, my lords. This is submission which we are making, my lords. My lord, we are only defending the, my lord, directions which are issued by the Union of India, and thereafter, my lords, of the Chief Secretary or the State of Nagaland, my lords. My lords, we are here to defend the, my lord, we are not here to challenge, but we are here to defend the directive or the notification or, my lords, the issued by the government of Nagaland. My lords, and my lords, we are, my lords, just assisting, my lords, to state that this is a valid notification issued in public interest. My lords, para 25, my lords, internal page 21 of the judgment.
Yes.
The learned counsel also submits that the Chief Secretary has a constitutional duty under Article 256 of the to ensure that the public safety and the well-being of citizens, and has full authority to issue the impugned notification since the consumption of dog meat is against the interest of the health of the people. Various scientific research papers, articles state that a dog meat trade endangers the human population due to risk of diseases like rabies, trachea infection, as well as increased antibiotic resistance. She further submits that dogs have been smuggled and brought into the market in pathetic state, where dogs are tied and put in gunny bags and with their mouth tied. Research like the illegal killing of dogs and their import-export running of dog farms to kill them for dog meat is indefinitely cruel and amounts to infliction of unnecessary pain. The cruelty to dogs due to trade is evident from the photographs, and these are, my lords, the arguments placed that this is cruelty should not be on dog, and we are on a pure legal point. That is, the states has decided that dog, they have defined two species which can be, my lord, slaughtered. Other than species, it can be, my lords, from elephant to tiger to lion to dogs. They cannot be slaughtered because they are not fit for human consumption. My lords, this is a domain expertise. The Food Safety and Authority of India is a domain expert, which are the meat which are congenial or which are conducive to human consumption and which are not. Therefore, my lords, once they have decided, an expert domain state authority, which is the highest authority, has decided, and the government of Nagaland has decided to implement the same. My lords, there is no as such infringement of any right which may warrant interference under Article 226 is our humble submission, my lords. And my lords, it has been ascend. And my lords, the finding is, my lords may also see, my lords, that para 31.
Yes.
The court finds it fit to first peruse the objective and preamble of the Food Safety and Standard Act of 2006, which is reproduced here. Very important, my lords. What is the aim, purpose, and purport of the act which is under which these directions have been issued? An act to consolidate the laws relating to food and establish the Food Safety and Standard Authority of India, which had issued the directions in 2014 itself, which is complied by the Nagaland in 2020. For laying down science-based standards, very important, science-based standards for articles of food and to regulate their manufacture, storage, distribution, sale and import to ensure availability of safe and wholesome food for human consumption and for matters connected therewith or incidental thereto. Now, this is the entire purpose and preamble of the FSS Act. Malas, I am reading further. Accordingly, the Food and Safety Standard Authority of India was established under Section 4 and 5 of FS Act 2006. The duties and functions of Food and State Authority is laid out in Section 16 of the FSS Act of 2006. Section 16 of the FS Act states that it shall be duty of the Food Authority to regulate and monitor the manufacturing, processing, distribution, sale and import of food so as to ensure safe and wholesome food. That the Food Safety and Standard Authority may be regulations specify various standards, guidelines in relation to articles of which have been listed in detail, which have managed this thing. Now, my lords, may turn to next page, para 32. These regulations have been framed under section 92. Regulations are 2011. Now, my lords, the bottom at page 6, para 32 bottom.
Yes.
Regulation 2.51 defines animal. Animal means animal, this, my lords. Carcass means, animals means, my lords, turn to next page, my lords.
Yes.
Ovines, caprines, salines, bovines, and includes poultry and fish. And later on, rabbit was added. So, these are the only animals which can be slaughtered, and for which there is an entire comprehensive code, safety of the, my lords, people who consume the meat, and also for ensuring, my lords, that the less cruelty is meted out to the animals. So this is a very comprehensive code both for the animals as well as for human being safety, my lords, of what they are going to consume. So and it's a domain expert. It's an expert person who decides what is fit for human consumption and at what level, and what is not unfit for human consumption. Now, my lords, carcass means the dead body or any part, including the viscera of any animal which has been slaughtered. Meat means the flesh and other well-off or carcass. Therefore, my lords, only the meat which is of the animals which are defined under 2.51a can be slaughtered for human consumption. No other animal. Now, my lords, domestic rabbits, I said, my lords, was also added in the definition of animals. My lords, I'm reading at page, internal page 27. Under the definition of animals, canine or dogs have not been mentioned. That learned single judge, with due respect, takes care of this, which is not surprising, since the meat of dogs is consumed only in some parts of northeastern states, and very idea of consuming cock meat is alien to other parts of the country. Now, my lords, this is how, my lords, the learned single judge tries to distinguish that since dog meat is not included, therefore, my lords, dog meat is outside the purview of the act, and therefore it can be slaughtered. No, that is not the reasoning. The reasoning is what is permitted to be slaughtered is included under the act. And whatever is not permissible to be slaughtered, it is not mentioned in the act. It cannot be that tomorrow, my lords, one can kill a tiger or a lion or an elephant because it is not mentioned in this. Only those animals which come within the purview of the act or whose, my lords, meat can be consumed by human consumption and who is fit for human consumption have been included. all other species have been excluded. Therefore, my lords, to say that since animals do not have dog, and therefore you can have any slaughter is, my lord, defeating the very purpose of the act. What can be slaughtered is inside the act. It's been laid down in the act. It has been provided in the act. What cannot be slaughtered is outside the act. It doesn't mean that what is not included in the act can be slaughtered without any restrictions. Therefore, my lords, this is how, my lords, this. Now, my lords, this.
Yes.
Now, my lords may occur to 38. Now, para 36, I have some problem with 36. And my lords, I will read from 36 onwards. It's a very short reasons as far as the reasons are provided, my lords. But they are short, that as to how this notification is for 4720 is bad in the eye of law. Now, my lords, the first is, my lords, para 36. In this court is constant to hold that Chief Secretary was not the appropriate authority to issue the impugned order dated this. Under Section 30 provides for appointment of Commissioner of Food Safety for the state of efficient implementation of food safety standards and other requirements. But the Chief Secretary is not, my lords, under the Act of 2006 issuing any order. It only merely reiterates what has already been pointed out by the authority earlier in 2014. So, Chief Secretary under our constitutional scheme is only, my lords, implementing the directives which have been issued under the Act. My lords, just for a moment. So, this is the first, my lords, with due respect, the error which has been done, which we wish to point out before my lords, and which back to my lords point out before my lords about para 36, that Chief Secretary was not having the power. Kindly see, my lord, section 16. My lords, have the Act of 2006, Food Safety Act. My lords, I think there is somebody there in the court. If we can hand over the Act. Food Safety and Standards Act of 2006.
Yes.
My lord says it, my lords?
Yes.
Section 16. Duties and functions of Food Authority, Section 16, my lords.
Yes.
Now, my lords, kindly turn to Section 16, bracket 5. The Food Authority, my lords, has it, 16.5, my lords.
Got it. Yes.
The Food Authority from time to time gives us directions on matters relating to food safety and standards to the Commissioner of Food Safety, who shall be bound by such direction while exercising power under this Act. Therefore, my lord, this 16.5 was exercised by the Union of India. Which, my lords, in my paper book, it is at page 193. My lords, adds it, my lords, page 193. Or 253, I think it is page 193. My lords has got it, my lords?
Page number?
Page number, my lords, 193.
Yes.
My lords, Food and Safety Standards Authority of India. A Ministry of Health and Family Affairs. Slaughtering of animals not permissible under FSS Act and regulations. Your kind attention is invited to regulations 2.5 of FSS Food Product and Standards Food Additives Regulations of 2011, wherein definitions of animal carcass and meat are given. So, my lords, they define, my lords, I have already read it, I am again reading it. As per regulation 2.51, animal means an animal belonging to any of the species specified below: ovines, caprines, sirloins, bovines, poultry and fish. Later on, rabbit was included. The slaughtering of animals by any of the other species, my lords, may note that, my lords, other than the one listed above, is not permissible under the FSS Act and regulations. In view of the above, you are requested to kindly strengthen the vigil and ensure the compliance of this. In pursuance to these directions, which was issued in 6th of August 2014, my lords, the Chief Secretary of my lords, the Government of Nagaland issued the impugned notification or the impugned directive of 4th of July 2020. They only want to state that whatever is permissible to be slaughtered and which can be distributed and fit for human consumption is provided under the Act by definition of animals. What is not fit for human consumption has been excluded. So all other species other than what is defined or what is prescribed under the Act are safe. They cannot be slaughtered. Therefore, my lords, may again read with due respect, with due apology, my lords, of 4th of July 2020, which is at page, my lords, 77.
Yes.
My lords, whereas the central government, Ministry of Health and Family Welfare has enacted the Food 72/2006 and the Food Safety and Standards Regulations of 2011 regulation to regulate the safety of food articles safe for human consumption. And whereas Regulation 2.51A of the FSA regulation meat and meat products, and as per sub-regulation animals means and animals belonging to any of the species below. Whereas the slaughtering of any other species other than the one listed in this regulation, these are the above 4 or 5 categories, is not permissible under the FAT and regulations. So therefore, my lords, with all due respects, both the central government, not the central government, my lord, the Food and Safety Authority of India, which is a statutory body under the Act of 2006, has come to the conclusion which are the animals which can be slaughtered and fit for human consumption. They have provided detailed, comprehensive code for that. And they have also stated that what is not prescribed under the Act cannot be slaughtered, cannot be, my lords, used for fit for human consumption. The government of Nagaland, my lords, the Chief Secretary only has issued a direction to comply with the, my lords, the domain expert view of Food Authority of India, my lords. And yes, please don't ensure that
Mr. Counsel, you
yes,
tell me, under the Act, who is authorized to issue such a notification?
No, my lords, notification is, my lords, the central government.
Yes.
Central government has issued directions.
Yes.
The Food Authority, not the central government, the Food Authority. And
Yes.
my lords, the government and the Chief Secretary is only ensuring its compliance. Chief Secretary is not, my lords, he is only ensuring compliance of the directions which are issued by the central government.
Yes.
And dehosts this argument without prejudice to this argument. My lords, can I say one more thing, my lords? If there is a scheme which says that these are the animals which can be slaughtered, then my lords, the government can always, my lords, today save all other animals from being slaughtered.
No, Mr. Counsel, you say there is a reference to one commissioner in the Act.
Yes, my lords.
Then whether the commissioner is supposed to issue the said notification or the Chief Secretary?
No, my lords, this is not, my lord, Chief Secretary is only, my lords, issuing a sequel to what has been already stated. He is ensuring only compliance. My lords, he is not, with due respect, my lords, if the Food Authority of India or my lords, there are various statutory authorities, if they are the domain expert, tomorrow it may be Aviation Authority of India or whatever, my lords. If they issue certain directions or they come to a certain conclusion or a decision and it conveyed to the state government, the Chief Secretary can say very well comply with this direction. It is not taking any independent decision. It is only reiterating what is stated by the government of by the food authority, food safety authority. Safety authority, Food Authority of India under the Act is the expert, my lords, is the domain expert, which can determine on basis of scientific study and all other relevant factors, which is the meat which is fit for human consumption. Then they come to a conclusion, these are the animals which can be slaughtered. Other species, please put a ban. The Chief Secretary says very well, we should ensure that all other species are protected. Because these are the animals, other than animals which are provided in the Act which can be slaughtered. No other species should be slaughtered. So there is no lack of competence on any part. It is only merely enforcing what is excluded as a species. All other species have to be protected. Dog meat is one of them. All other species, it will include, my lords, all other species. It may include, my lords, even a lion, as I said, my lords, or a tiger or elephant. All other species have to be protected.
Okay.
That's our submission, my lords.
Okay,
And therefore, my lords,
under the act,
my lords, this can be other Act provides only for killing.
who has the authority to issue such
My
order?
lords,
Under
no,
the
my lords. Under the Act is the authority, food and authority, the food authority.
in the central.
Food authority, which is constituted by, my lords, under the Act.
Authority of India.
Yes, my lords.
India.
Food
Okay,
safety.
and in the state, who has the authority to issue?
My lords, state is compliance. State is only complying is what we say.
Compliance order who can issue this compliance order?
My lord, Chief Secretary can issue.
Where is the in the act? It is
No,
provided.
my lord, it is not in the Act. My lord, there are.
In the act, who is the authority as per the act?
No, my lord, what happens is, my lord, my lord, with due respect, my lords are correct.
The Commissioner of Food Safety.
No, my lord, food
For who?
safety is bound by such directions. That is one part. But the Chief Secretary is not denuded of his power to my lords, comply with any directions issued by any authority of the Government of India.
The Chief Secretary or any other designated commissioner or officer who
My
can
lord,
issue that order?
My lord, Chief Secretary is only complying with the orders passed by the, well, not orders. It is a directive issued by the Food Authority of India that please ensure that no other species is slaughtered.
That we understand, but the authority who can issue? My specific question.
My lord, it is an executive order which is issued in compliance of an order passed by the domain expert and the statutory body, Food Authority of India. My lord, it can be Aviation Authority of India. It can be various statutory bodies which are of, my lords, are there. They may issue various directions. And the state has to come, state Chief Secretary will ensure its compliance because it is the head of the executive in compliance is concerned. So there is no policy direction. There is no application of mine. It is only an order of enforcement of what has been directed by the Food Authority of India.
Okay, all right. We will resume at 2 o'clock.
My lord, I continue at 2 o'clock, my lords?
Yes, 2 o'clock.
Very well.
At 2 o'clock.
Very well. Obliged.
For example, I don't know about.
I beg to appear, my lord. Am I audible, my lord?
You're audible, otherwise, the judges have not yet come, but otherwise audible.
Okay.
Bilaj, I'm appearing in Writ Appeal 7. I'm sorry, I was held up at that time. I wasn't here. What about it?
Or 57.
Court Master?
Yeah, yes.
Yes, I'm appearing in Writ Appeal 7
Yeah.
for the appellant and for respondent number 9 in this writ appeal number 12.
Okay, you're clear.
Yes, thank you so much. Kindly just note down the appearances as and when they come. Thank you. Who's there in the port? Who's there in the port? Okay.
My lord, may I begin, my lord?
Yes, yes.
My lord.
Milaj, I'm appearing in Writ Appeal. Milaj, I guess 1 minute. Milaj, I'm appearing in Writ Appeal 7. After my learned friend Milaj finishes, then would be Milaj's assistant lordships, lords, and that.
Madam, you are not audible.
Can my lords hear me, Milaj?
No.
Milaj, your lordship can't hear me. Milaj, now your lordships can hear me?
Yes.
Yes, as well as I'm appearing in Writ Appeal 7.
Yes.
After my learned colleague finishes, then I would need to add on to the submissions, Milords, and make my submissions in the Writ Appeal.
Okay.
We are also impugning the order, Milords.
Okay.
Yes, my lords. Grateful, my lords.
Now, my
Yes.
lord, my lords, as my lord said, has posed a query, my lord,
Yes.
that about that, my lord, there is one thing is very clear, which is uncontroverted, that the directions which are issued under 16(5)
Mm.
are statutory nature and passed under the law enacted by the parliament.
No, there is no doubt about it. There
Yes,
is
my
no
lords.
trial at the bar about it.
Therefore, if the
The
6th
question
August
is, what my learned brother put the question to you is, who is
Yes,
the
I'm-
state authority to issue such a notification under the Act?
I'm coming to that. Therefore, my
Yes.
lords, as on date, my lord, if the 6th August 2014 order is not challenged, and I am given to understand it is not challenged, then the state of Nagaland, dog, no other species other than mentioned in the act can be slaughtered. Who
Yes.
does it in the state of government is the second point
Mm.
or a subsidiary point. The main point is the 6th of August 2014 notification is passed under the law.
Mm.
Therefore, my lord, the state of Nagaland has to follow the law.
Mm.
Now, my lords, there can be one view that commissioner will ensure the safety. If the commissioner does not ensure the safety, then any person can come to the court and ask the commissioner to ensure the safety.
Mm.
Or, which is defined in section 30, or the chief secretary may say that since it is a central directive by statutory authority, please comply. He may pass a direction to the food commissioner.
Yes.
Or to the general public, or that please ensure the safety and reliance. Therefore, my lord, the genesis or my lords, the basis of the entire, my lords, this entire law is 6th of August 2014.
Mm.
My lords, it will take care of another my lords, reasons which has been found here with a single judge is at para 38. Why I am saying this is, my lord, in the background of what has been stated in para 38. Para 38 states that the chief secretary has passed an order which is executive in nature, not backed by law.
Mm.
So that our answer is that the chief secretary has, suppose one of this order of central government was not there. I'm just giving a hypothetical situation. Then one could have said that in under what powers chief secretary has issued such an order. But here there is already an order by under the law of the central government of 6th of which empowers the food authority to issue directions. 6th of August 2014. So this 6th of August 2014 is backed by law.
Mm.
Therefore, the reasons which is now this is backed by law. 6th of August 2014 is not challenged.
Mm.
Therefore, as on date, state of Nagaland, there can be no slaughter of species other than mentioned in the act, which includes dog meat.
Yes.
Therefore, my lords, kindly see, but the single judge has, my lords, proceeded on the assumption because 6th August 2014 was not challenged. The single judge has given a reason that since it is an executive order passed by the chief secretary, not backed by law, therefore it is a bad in the eye of law.
Yes.
It has not gone into the hygiene aspects of dog meat or the culture aspects. No. It has, kindly see para 38, my lord. May I read that?
Yes.
My lords, it has been seen that the petitioner are said to have an import-export permission issued by this, which allows the petitioner to import dog to and earning their livelihood. That is 19(1)(g) argument. The impute notifications 4720, which is the chief secretary of compliance, it is not an independent application of mine. It is only compliance directive. Can be said to affect the petitioner's earning capacity. Fundamental rights are 19(1)(g) and 21 of the Constitution to earn his livelihood and the freedom to consume food of his own choice. However, can be restricted by reasonable restrictions prescribed by law. Therefore, this is a prescribed by law is, my lord, that the order passed which is by the central government of 6th of August 2014. It is prescribed by law.
Yes.
That is our submission. Therefore, this is my lord, this is how the error has crept in, because the 6th of August 2014 was never challenged.
Yes.
And they have proceeded on a standalone of 4720. But the fact of the matter is 4720 is not an independent executive action. It is only a compliance directive. It is not a directive of infringement of fundamental right. Infringement of fundamental right, if at all, arises from 6th of August 2014, which is backed by law. Therefore, my lords, the prohibition of sale and consumption, when I am reading para 38, last two lines, the prohibition of sale and consumption of dog meat by the executive branch of the government without there being any law passed or legislation in the relation to trade and consumption of dog meat is thus liable to be set aside.
Which line you are reading?
My lord, my lord, the main operative part of the entire judgment, which is set aside this notification of 4720, is para 38.
Okay,
I will read it again, my lord.
38.
Yes.
Para 38. Internal page 32 of the impugned judgment.
Last line. The prohibition.
Okay.
No.
This one.
Yes, no, yes, from that 38, that the
Yeah.
prohibition,
Yes.
last line.
Okay. Yes.
The prohibition of sale and consumption of dog eat by the executive branch, that is the chief secretary, my lord, of the government, that is of 4720. Without there being any law passed by the legislation in relation to trade and consumption of dog meat is liable thus to be set aside,
Yes.
even though the impute notification of is said to have been passed in accordance with the cabinet decision. And they cited two judgments which says that if there is violation of Article 19 and 20, it should be passed by a law. Our submission is, my lord, humble submission, my lord, before my lords, that this 4720 is a compliance directive. The main directive is backed by law under 16 subclause 5, which says that there will be no slaughter of species other than mentioned under the Act of 2006, which defines animals, 5 categories. And my lord, this irony is that this Government of India directive of 16.5 under the law, statutory power, statutory order of 6th August 2014 is not challenged. In compliance of 6th August 2014, Chief Secretary say, please comply with the order. Now, Food Commissioner will of course ensure its compliance. But as long as 6th August 2014 is not challenged or is a valid order prescribed by law, it can infringe Article 19(1)(g). Or else therefore it will pass the test of reasonable restrictions. And therefore, today, it is our humble submission, dog meat cannot be, the dog cannot be slaughtered in the state of Nagaland. No other species other than mentioned in animals, which is defined under regulation 2.5.1a, which I have read 2-3 times, my lord.
This 6
No other
August, 6 August 2014 is issued by Food Safety and Standard Authority of India.
Yes, under 16.5.
This is in respect of all in India.
Yes, my lord.
Okay, now we are talking about the Nagaland, state of Nagaland.
It will apply to Nagaland also.
But unless there is
no, my lord, there is no separate order to be required.
Observe in page 38.
My lord, there is no separate order which is required to be passed by the state of Nagaland. The Food Commissioner will be bound by direction. Kindly see 16.5. It is not that the state government has to further apply his mind. The state government will just comply with the directive.
Oh, you mean to say the executive, the state legislation doesn't legislature doesn't have to pass any order into it, and the executive order will.
Yes, my lord. Because it is
by executive order, it can be banned.
No, my lords, I am not saying that. It is banned by the central government. Not central government, I am sorry, my lord. It is banned by the Food Authority of India. It is under the Act, backed by law. It is not banned by the state of Nagaland standalone. That is the, my lord, with due respect, error committed by the learned single judge.
So
He
you
says in
this
state of Nagaland has banned it. No,
Hmm.
it is the government of India. Sorry, not the, my lord, sorry. It is the food authority under the Act of 2006, backed by law. That this order
And
has
and it has to be implemented in the state automatically, you mean to say?
but it has to be implemented by the state of Nagaland, by the food commissioner
Automatic.
and the chief secretary. Yes, my lord. There is no separate order to be required to be passed. Kindly see 16.5. It says that food commissioner will be bound by direction. So today the food commissioner has to implement this law directive. And my instructions are, my lord, that it has not been assent. The 6th August 2014. What they have assent is, what they have challenged is, with due respect, the implementation part. They have not challenged the source of the entire exercise. And the learned single judge, my lord, I don't know, my lord, but the learned single judge has just gone on this aspect. There is a chief secretary on its own has issued some direction. And therefore it is bad in the eye of law. Our submission is chief secretary has merely sought to comply with the statutory order passed by the statutory body under the Act of 2006, Food Safety and Standard Act. There are so many minor directives which are issued under the central acts or even the state act sometimes minor issues directives. The chief secretary says, okay, I will ensure it. The lawmakers, when they make the law and the orders are issued under the law, then the chief secretary and secretaries are bound to implement that particular direction. It is so the chief secretary order of 4720 2020 is only an implementation or enforcement order. Even if it is, my lord, even for the moment it is set aside. I'm just maybe hypothetically saying. Then also, my lord, the order of August 2014 shall continue to remain 6th August 2014. And the state of Nagaland will have to comply with this. Maybe food commissioner will have to comply. Food commissioner is also part of the executive. The chief secretary just has issued notices to all the bodies that please ensure that there is no killing of the species other than animals which are prescribed under the act. It is not dog alone, my lords. I'm so sorry. Dog, people who trained in law came to the court. But otherwise, this directive of 6th of August 2014 applies to all the species, which may include, my lords, all the species other than some limited animals which are mentioned in the act. Bovines, caprines, salinas, bovines, poultry, fish, and rabbit. All other animals are protected, including dog. But it is only dog that, my lords,
Okay. Okay. Do you have any?
And my lords, yes, my lords, sorry.
Do you have any other ground?
Yes, my lords. There is one more thing which I want to say.
Yes.
So that Article 21, my lords, kindly, I have read para 38. He cites two articles of the Constitution. One is 19, my lord, Learned Single Judge relied upon two articles, 19(1)(g) and Article 21. And my lords, it doesn't say that, it says that because both of them, if you want to right to eat, my lords, first of all, my lords, what is unfit for human consumption, one cannot say that it is my right to eat. Right to eat will only arise if you have it's fit for human consumption. This is one point. Article 21, my lord, secondly, is now the emerging jurisprudence is multi-species. It is not only for the person alone. It is for the animals alone. Animals also. So, my lord, our jurisprudence has extended the rights to animals also. So, the animal, man, my lord, interface has to be seen. You cannot say that because he's an animal, I can do whatever I like with the animals. So the entire jurisprudence of my lord's compassionate towards animals is Article 21. So Article 21 is equally extended now to the animals, especially in relation to men. Therefore, my lords, the reliance on Article 21 with due respect is not, my lords, founded on sound, founded on constitutional jurisprudence. But yes, Article 19(1)(g), yes, people who trade in dog meat may have a right to trade in dog meat, but it is subject to reasonable restrictions. What is the reasonable restriction? Reasonable restriction is on the template of being fit for consumption. So, my lords, the whole idea is, the scheme of the thing is that everything is right to trade is fine, but it is subject to right to health also of the citizens. So, state can always, my lords, provide standards for the purposes of reasonable restrictions. Kindly see 19(1)(g), my lords. My lords of the Constitution.
Yes.
So, my lords, Article 19(1)(g), my lords has it. My lords, Constitution
Yes, yes.
19(1)(g).
Got it.
Sorry, oblige, my lords. All citizens shall have the right, 19(1)(g), to practice any profession or to carry on any occupation, trade or business. So it's in their trade. No, but my lord, they have. Now, my lords, 19(1) is now, my lords, subject to reasonable restrictions under Article 19(6). Nothing in this sub-clause G of the said clause shall affect the operation of any existing law, insofar as it imposes or prevents the state from making any law imposing in the interest of general public. Now, my lords, it is hygiene in health and safety of individuals is interest of general public. Reasonable exercise on the exercise of right conferred under said clause, and the particular nothing in this shall affect operation of existing laws or relate to prevent. My lord, this is not relevant. So, therefore, my lords, they can provide reasonable restrictions in the interest of general public. So, what is unfit for human consumption? It may is, my lords, banned. So, what is this? And the 6th of August 2014 notification is by the Food Authority of India, which is the highest domain expert body, statutory body, constituted to determine what is fit or what is unfit. And my lords, many countries which historically might have, my lords, have dog, my lords, meat, have now banned it. Philippines and South Korea, I'm told, have banned it, my lord. And my lord, it is a and the authority of Food Authority of India, is a statutory body. It has issued a notification. Nagaland government is bound by it. The state of Nagaland has not taken a decision independent of any government of India. It is in sync or consonance or conformity with the Union of Food Authority of India's directions. It may be Chief Secretary, it may be Food Commissioner. So our contention is, irrespective of the direction of the Chief Secretary of Food 2020, the state of Nagaland, the operative part of 6th of August 24 remains operative. The Food Commissioner is bound to ensure that there is no slaughter of any species other than animals.
Okay.
Even if the learned single judgment is not there, my lord, it is bound to be, because learned single judge has quashed it. Now state government cannot enforce it.
Okay.
So that's our submission. So, my lord, and my lord, Article 21 is not that any citizen has a right to eat a particular. This is, my lord, because one has to see the approach of what is known as multi-species approach or not. We have to abandon this Anthropocene approach of having only human-centric approach. But my lords, I am not going on that. The main contention of ours is Article 21 is equally extended to animals.
Yes.
But and the FSSAI is not going on animal even in interface. FSSAI is going because the particular animals which are conducive to to human health have been permitted on certain conditions and which have to be followed.
Okay.
And other animals have been banned. It operates throughout India.
Yes.
Including the state of Nagaland. Chief Secretary has mainly said, please comply with it. That's it, my lords. And my lord, therefore, my lords, this judgment, my lord, is and my lord, 6th of August 2014 remains in force. And my lord, 4720 is only a compliance order. It is not a separate order which has been passed under the Act or something, my lord. Just an executive order to comply with the directive issued by the Food Authority.
Okay.
And therefore, my lord, this operative part that is not backed by law is also expressly, with due respect, erroneous.
Okay.
Which is backed by section 16 sub-bracket 5 of the Act of 2006.
Okay.
And
Yes. Item
I'm
number.
very obliged for this patient hearing, my lords. Very obliged.
Yes, madam.
Yes, my lords. So, my lords, I there the writ petition, my lords, writ appeal 7. And
Yes.
my lords, in this present appeal, I'm respondent number 9. This came later. Anyway, my lords, be that as it may. So, my lords, I will take it further from where your lordships have heard, my lords. My main proposition, my lords, is this. One, my lords, the prayer, as your lordship heard, my lords, is challenging the notification by the state, my lords, of 4/7/2020, my lords, which is the only one under challenge, my lords. Now that, my lords, having been said, this follows pursuant to, as my learned friend also said, my lords, pursuant to, my lords, a centre's circular of 6/8/14/14, 2000. thereafter followed by a cabinet meeting at page 160. So, my proposition is the following. Firstly, a coordinate bench of the High Court of Gauhati in Hizbur Rahman has upheld the circular in terms. So, if your lordship, I may pass on the judgment. Start with that, Hizbur Rahman, sorry, is passed by my Lord Justice Pathak and my Lord Justice Manish Chaudhary, I may take your lordship, in this judgment to paragraph number 2,
Yes.
The Secretary to the Animal Welfare Board of India, in short, Ministry of Fisheries, Animal Husbandry and Dairying, Government of India, by its communication number so-and-so dated 7/6/22, communicated to the Chief Secretaries of all the Director and illegal killing, oblique sacrifices of cows, calves, camels, and other animals, and taking action against the offenders for violation of transport of animal rules on the occasion of Bakrid, stating that large number of animals are likely to be slaughtered during Bakrid festival, and it is reported that during the transportation of animals, the owner of the
Yes, madam, you are not audible now.
Let's just use another system. I'm so grateful, Manoj.
Okay. Okay.
Yes. So, Manoj, I was just reading from Hifzur, Manoj, the judgment, the division bench of the High Court of Gauhati, Manoj.
Yes.
So, Manoj, in this, if your lordship will come, the challenge was, Manoj, to, in this case, to the circular, Manoj. And considering this, Manoj, at paragraph, Manoj, 31, paragraph 31, Manoj.
Yes.
Page?
Manoj, page is, Manoj, this is an online version, I believe.
Okay,
The page is 7, Manoj. Has your lordship got the copy of the orders, Manoj?
Yes, got it. Para 31.
Yes, Manoj. I'm sorry.
Yes.
Yes, para 31. And this, Manoj, the letter dated 7/6/22 has mention of animals as an animal belonging to the species, Manoj. And I may repeat, Manoj, that the impugned order itself says dog is not food under FSSAI. That has been accepted as a proposition. If your lordship will take line 6, Manoj, approximately, starting from, it is apposite. State that section 92 of FSS Act 2006 has empowered the Food and Standards Authority of India, the Food Authority in short regulations, with the previous approval of the central government and after previous publication by notification consistent with the FSS Act 2006 and the rules made thereunder to carry out the provisions of the FSS Act 2006. Clause E of subsection 2 of section 96 has empowered the Food Authority to notify standards and guidelines in relation to articles of food meant for human consumption under subsection 2 of section 16 of the FSS Act. Then if your lordship will take, Manoj, paragraph 37, I'm sorry, Manoj, at page 13, it's the last page.
Yes.
In the concerned view, Manoj, at the bottom of the page, in the concerned view of this court, that the directives contained in the letter dated 7/6/22 of the Secretary of the AWBI, nor the directives contained in the letter dated 4/7/2022 of the Personal Department of the State to the writ petition, which have been issued in deference to the letter dated 7/6/22, are found repugnant to any of the provisions contained in the Prevention of Cruelty Animal Act and the rules and regulations framed under it, the Food Safety and Standards Act 2006, including the rules and regulations framed under it, as well as the Assam Cattle Preservation Act 2021, including the so-and-so. Because in that case, cattle were also involved. Therefore, the reference
to other animals. In our case, my lords, it's only dogs that are involved, my lords. And of course, my lords, in any case, today the issue of dogs is also at large in the Supreme Court in another context, my lords. Be that as it may, my lords. So Hifzur Rahman, my lords, in terms, my lords, upholds the circular, my lords, of the government dated 6/8/14. Correct. That's a parent circular which is at page 186 of the current writ appeal, my lords. It's the same circular, my lords. So in terms, this has been upheld,
Yes.
my lords. And your lordship would just look at it again, my lords, for a moment at page 186 of our writ appeal, my lords, number 7.
Okay, okay.
Your kind attention. Yes. Yes, please. Just give me. Just give me, please. Need that document back. So
Yes.
this in terms is the same circular, my lords. Yes. Now, my lords, my two propositions, my lords, which go further than this, my lords. Firstly, my lords, just covers the issue because the center's circular, my lords, having been upheld, my lords, by a coordinate bench of this court, my lords. And, my lords, this would be binding, I would assume, my lords. And secondly, my lords, in addition, what your lordship will refer to is, my lords, two propositions of law. One is, my lords, in section 86 of the FSSAI Act. This act, my lords,
Section?
Section 86. That's a source of power, my lords, of the central government to give directions to the state government to take actions, which it has done in the present case. Section 86.
Yes.
Power of central government to give directions to state governments. The central government may give such directions as it may deem necessary to a state government for carrying out all or any of the provisions of this act, and the state government shall comply with such directions. So, because the state is mandated to act in accordance with the directions of the central government wide circular dated 6/8/2014, which has itself been upheld in Hizbur and not challenged in the present petition in any case. So, let's to repeat this proposition, I rely upon section 86 of the FSSAI Act to say that the state government was mandated and accordingly acted. And to just take the sequence through again, my lords, at page 186 of the writ appeal, my writ appeal, is the center as well as directions, which your lordship just saw at 6/8/2014. Thereafter, my lords, at page 160, is a cabinet meeting, my lords, of the state, dated 3/7/2020.
Yes.
Where, my lords, the state cabinet has decided, my lords, kindly see paragraph 2. The top, my lords, agenda number 8, ban on import and sale of dog meat in the state. And number 2, the cabinet, after due deliberation, decided for issuance of orders banning the following. 1, commercial import and trading of dogs and dog markets. 2, commercial sale of dog meat in markets and dine-in restaurants. Necessary orders will be issued by Chief Secretary in this regard, backed by relevant sections of law, and the same will be enforced by district administration, police, municipal administration, and the veterinary and animal husbandry severally as well as jointly. Now, this again, my lords, is not under challenge. The only document, only notification under challenge is the one issued by the Chief Secretary at page 161. So, my lords, 186 is the first starting point of the center, directing the state government. At page 160, the cabinet, pursuant, my lords, to several directions of the central government, has, my lords, passed these orders, my lords, and given directions to the Chief Secretary specifically to take action and for the implementation. And, my lords, I would add here one more provision which is paramount to Article 256 of the Constitution.
No, madam, you tell me one thing. In Nagaland, the Commissioner Food Safety is appointed?
Yes, my lords. I believe. I don't know. They'll have to tell. But
If
there is provision in the
if,
budget. I don't know.
if the act provides that the commissioner has to issue any notification, then whether this cabinet memorandum will change the legal position, that instead of the commissioner, the chief secretary will issue the notification.
Manoj, with due
If,
respect, Manoj, I just
something
pointed
is
out.
provided in the statute to be done in a particular way, whether the cabinet has the authority to change the same.
Manoj, my respectful submission is, Manoj, section 86 of the FSSAI
Yes.
empowers and gives right to the central government to issue directions to the state and to take action in accordance thereof, in addition to the rights of the food commissioners. I am not going away from the food commissioners, because I am not saying they have some power or they don't have. They may have whatever powers they have, section 30, etc. But section 86, Manoj, is a separate specific power which empowers the center to give directions to the states and the states to take action in accordance thereof. And that, Manoj, cannot be taken away.
Okay.
So, Manoj, that is in addition. I would again submit, Manoj. And food commissioners, Manoj, in any case, Manoj, they have their own actions. As I said, I am not arguing against that proposition. Manoj, that is whatever powers they have. This is provided in the statute, which is, Manoj, passed by the parliament, upheld, and Manoj, the state of Nagaland has in various ways, I filed an additional affidavit, enforced the entire act, Manoj. I'll show that also to your lordship after this in a minute, Manoj. But before, may I take your lordship to Article 256 of the Constitution?
226.
256, Manoj.
Okay.
256. The executive.
Yes.
So, Manoj, the executive power of every state shall be so exercised as to ensure compliance with the laws made by Parliament and any existing laws which apply in that state. And the executive power of the Union shall extend to the giving of such directions to a state as may appear to the government of India to be necessary for that purpose. So, Manoj, the Parliament, Manoj, has empowered the exercise of powers by the state in compliance with existing laws, which is FSSAI. And Manoj, the executive power extends to giving directions, which is parameteria to some extent to section 86. Of course, the constitution is way above any Manoj. The law of the land, Manoj, is FSSAI. FSSAI under section 86 empowers the center to give directions. Such directions are given by the center. To go back, Manoj, to 186, if your lordship will see, Manoj, 186, in fact, is CC'd, Manoj, or addressed to all the food safety commissioners. So, Manoj, in accordance with this theme that the Constitution has provided and the Parliament has provided, and Section 86 in particular, Manoj, and the fact that the circular, the original directions, neither are impugned, in any case upheld by a coordinate bench in Hizbut, Manoj, though in somewhat different contexts, but the same notification, Manoj, which is under challenge. And that is not even being challenged. So that was the additional part that my learned friend was saying, Mr. Singhvi, that basically, Manoj, the earlier ones having been not even been challenged, the later one is only a carrying out of implementation. Here, Manoj, the cabinet has authorized the chief secretary in pursuance of the laws of the country to take action, Manoj. And that is the action that has been taken, Manoj. So in these circumstances, Manoj, I know what your lordship says, Manoj, 1936 Privy Council, the law must be what must be done in the manner required, Manoj. It is being done in the manner required. There is, there is no such ambiguity in this provision, Manoj. And therefore, Manoj, I'll just show one more documents to your lordship, Manoj. And that, Manoj, is the implementation of the FSSAI Act in the state of Nagaland. If I may, Manoj, we had filed an additional affidavit, which is dated. This is only to supplement, because I don't think there's any dispute on this. Nobody's disputed the fact that FSSAI applies to Nagaland. Where is that? I keep saying it. This is So, belows in this affidavit of 28/2/25, at paragraph 4, page 2. Your Lordship was asking Manoj regarding the act also.
Yes.
Yes, Manoj.
Paragraph.
Manoj, this is page 2 of this
Yes.
affidavit 28/2/25, paragraph 4.
Yes.
That the answering at the bottom of the page was that the answering deponent humbly submits that a perusal of the website of Department of Health and Family Welfare, Government of Nagaland indicates that the Food Safety and Standards Act 2006 and the rules and regulations promulgated thereunder have been adopted in the state of Nagaland and are being implemented by the statutory authorities under the said act from the year 2012 to implement national health programs. And then below the extracts are actually below annexed of the website below, along with the affidavit. Then below paragraph 5, the answering deponent submits that it is stated on the website of Department of Health and Family Welfare, Government of Nagaland, that the Directorate of Health and Family Welfare, Government of Nagaland through the department is regulating and monitoring the manufacture, storage, distribution and sale of food articles through the Food Safety and Standards Act 2006 and the rules and regulations framed thereunder. These are at pages 11 and 12 of this affidavit. The Lordship will just have a glimpse of it, my lords. At page 11 is the Directorate of Health and Family Welfare of Nagaland. At page 12, at point 1.5, the third item is prevention and control of communicable and non-communicable diseases, including locally epidemic diseases. The fifth one, my lords, is promotion of healthy lifestyle, my lords. And the page over is item number 8. Control of drugs and safety of food articles through the Drugs Control and Cosmetics Act and rules and the Food Safety and Standards Act and rules. The department regulates and monitors the manufacture, storage, distribution and sales of drugs and food articles. Then if your Lordship would go back to the affidavit, minutes kindly to page number 3. Your Lordship will find paragraph 6. That the answering deponent states that a perusal of the Nagaland Rules of Executive Business 2020 reflects that the business of the government has been allocated between various government departments in the state of Nagaland in terms of Rule 4, first schedule. Rule 4 prescribes that the business of the government shall be transacted in the department as per point number 15 at page 19. I'll just show it to your lordships. Of the first schedule, the statutory duty of implementation of the National Health Mission through the Food Safety and Standards Act has been allocated to and is being carried out by Department of Health and Family Welfare, Government of Nagaland. Your Lordship will kindly turn over to page 19 alongside with me, minutes. Page 19, minutes. If your Lordship will see clause number B, medical B branch, under that, your Lordship will find O, Food Safety and Standard Act. If your Lordship will just go down approximately 10 lines, your Lordship will find there's National Cancer Program that is not relevant for the present case. Then there is Food Safety and Standard Act. If your Lordship sorry, has your Lordship got that?
Yes.
Then if your Lordship would once again go back with me with us to the affidavit at page 4, para 7. This is the annual administrative report 2019-20 published by Department of Health and Family Welfare, Government of Nagaland. It is at page 21, but your Lordship can read it from here. Food Safety FSSA Act. Food Safety Nagaland under Health and Family Welfare is responsible for implementation of Food Safety and Standards Act, rules and regulations in our state. The main objective of this act is to ensure availability of safe, hygienic, nutritious, and wholesome food for human consumption. Whereas admittedly, dog food is not, my lords, fit for human consumption. That, my lords, has been so held even by the impugned judgment, and it is not covered by the Food Safety Act. Food safety contributes to food security, human health, economic prosperity, and sustainable development. Thus, food safety is everyone's business. And this, my lords, will find at page 21. I have extracted it for your lordship's relevance, reference here. There are 5 lords. There is appointment of food commissioners, my lords. Your lordship was asking, there are food commissioners. And they are also mandated, my lords, the central government, to go back to page 186, has marked it to food commissioners. And yes. And my lords, if I may once again come back to the factum of the section 89. 30, my lords, is only for 1 year. The appointment of food commissioners, section 30, please. Section 30 is only appointing of food commissioners for 1 year for whatever purposes, my lords, as stipulated therein. Section 86 overrides, my lords, and provides plenary powers, my lords, to central government to give directions to state governments, and is not in any manner in derogation of the power of food commissioners or otherwise, my lords. It serves the purpose of the act, and Nagaland, my lords, the state of Nagaland, has in terms adopted the entire act, my lords, and is bound to carry out, my lords, the directives of the central government so passed, my lords, and directed to the state government. And state government, my lords, has in any case, my lords, worked in this direction as fully demonstrated in our affidavit. It is not so, my lords, it's that something which is coming afresh. And, my lords, when something is not covered, my lords.
Yes, madam, regarding adoption of the act by the state, whether any notification was issued to that effect?
My lords, we do not have any recourse to any notification as such, but I have shown your lordship the state of Nagaland, my lords, adoption by active practice, statement, and stipulation. So, my lords, once the state has chosen, my lords, to do this action, my lords, I cannot go behind what the state does. But the state in terms has said that it is bound and is implementing the act. And, my lords, if the state has so chosen, and that action is not in any manner, my lords, impugned by anybody in this court, my lords, or in the writ court, then that cannot be the source of any dispute, my lords. The state is saying, my lords, all those websites, the declarations, I've so shown, and so has, my lords, FSSAI has in terms, my lords, also supported, my lords, in the counter affidavit in WA, my lords, 7, in as many words, my lords.
So,
that
kindly show us one document showing that state of Nagaland has adopted.
Yes, my lords. I just shown your lordships. I'll again show them, my lords. Affidavit. I'll just go back to the same affidavit of 28 to 25. Just take this on this. This is allocation of business. No, I'll come straight away. So, if your lordship will take page 90, page 20, my lords, of the said affidavit. I'm sorry, page 19 first. That is part of the allocation of business, my lords. Just 1 minute, please. And
19,
that, my lord,
19 of the
affidavit of 28 to 25, my lords. The additional affidavit, your lordship was just reading it with me, my lords.
affidavit of
the affidavit of the appellants, my lords. Us.
additional affidavit.
Yes, my lords. 28 to 25. That might be the last document filed, I believe. My lords, it starts from 14, page 14. This is the Government of Nagaland Allocation Rules of Executive Business 2020. At the top, your lordship will find that. Has your lordship got that, my lords?
Page
14.
Yes.
Government of Nagaland, Department of Personnel and Administrative Reforms, the Nagaland Rules of Executive Business 2020. Here, my lords, if your lordship will turn over, my lords, to page 17, my lords. That is the allocation of business. And then finally, my lords, to page 19, 19. At the top, my lords, you'll see number 15. This is line 5. Health and Family Welfare Department. What has been allocated, your lordship will go down the list, my lords. From the bottom, my lords, approximately line 7, at serial number 0, O, it says Food Safety and Standard Act. Has your lordship got that, my lords? Lords, has your lordship got the Food Safety and Standard Act?
There, safety is mentioned somewhere.
Is it there, but this document is this issue and it is there, of course. Second time. But this is it's there, but then you into this. So by virtue of this, the state has adopted this site according to our science. Okay, this is over. So can you meet this doctor? Very likely do instead.
Okay, yes, madam, please continue.
Yes, my lord. So at page 19, I had shown to your lordship, my lords, clause number O in point B, which is part of the Health and Family Welfare Department, specifically, my lords, Food Safety and Standard Act. Then, my lords, yes, near the bottom, my lords.
Yes, we have seen it.
Yes. Then, my lords, if your lordship will take page 20, this is the annual administrative report of the state of Nagaland. At page 21, item number 19. Food Safety Nagaland under Health and Family Welfare Department is responsible for implementation of Food Safety and Standards Act FSSA rules and regulations of our state. The main objective of this act is to ensure availability of safe, hygienic, nutrition and wholesome food for human consumption. Food safety contributes to food security, human health, economic prosperity and sustainable development. Thus, food safety is everyone's business. And then, my lords, at the bottom, activities report, there are all the state licenses also issued by the state of Nagaland. If your lordship will see the bottom, total existing FSSAI state license holders is 496.
Okay, all right, all right.
Yes. So, my lords,
do you have any other ground?
Well, as such, these are the grounds that are available, because the only question, the impugned order, in fact, goes all the way to say dog meat is not food. That is established. It only goes on, further to say that the chief secretary was not empowered. So, my only, reasonable, duty to your lordships is to demonstrate that the chief secretary has the power to do so, my lords, has been authorized by the central government, has been directed by the central government, and to do so, my lords. And hopefully, my lords, that should be able to, my lords, achieve the target, because ultimately, my lords, Article 256 and Section 86 of the FSSAI Act, my lords, are paramount and give such directions. Also, your lordship, my lords, is bound by the coordinate bench of this court, my lords, which holds and upholds the centre's directives, my lords, which have not even been challenged in the present petition in his board. So, my lords, I would only add one feature, my lords. We are talking about public safety, my lords. We are talking about public health. Issue here is not of anything else but that. the fact that dog meat has been held to be not food, even by the impugned judgment, corroborated from the various sections of the FSSAI, it's an admitted position. In such circumstances, my lords, not to uphold the directions of the central government would, my lords, be totally, my lords, antithetical to public safety, public health, and the interests of the state, which is already, my lords, in the active process of implementing the act in all ways, my lords. And therefore, my lords, this exclusion is, my lords, would be absolutely, my lords, uncalled for. And the power of the Chief Secretary, my lords, with the cabinet decision, my lords, nothing survives, my lords, as such for consideration. But, my lords, there were some other supplementary, my lords, arguments, but I would, my lords, for the time being, my lords, reserve my rights here, my lords. And if your lordship in any manner has any questions, my lords, I'd be happy to, my lords, address them to say so.
Okay, all right.
Yes, just for a matter of reference, my lords, Article 256 and Section 86 in terms have been, my lords, mentioned, and in specific terms, my lords, at page 5 in a counter affidavit in writ appeal 12. In the matter that Dr. Singhvi was arguing, my lords, I am appearing for respondent 9 in that, my lords. In a counter affidavit of respondent 9 at page 5, I specifically enumerated, my lords, the articles and the section which I have just, my lords, labored to, my lords, go through that, my lords, and it's a constitutional duty, my lords, to carry out, my lords, such directions as are made for the welfare of citizens of this country.
Okay. Yes.
There are various, my lords, the danger zones. I could, if I can just, my lords, I'm sorry, just one last part. My colleague has just asked me, my lords, to add. My lords, there is the health hazards of dog meat being consumed, my lords. If your lordship could just refer to page. What page is it? Where is the note? There is a note 306. Yes. So, my lords, if your lordship will just see pages 306, 315. So let's start with 306, my lords. I'll just show a few of these, my lords, and the rest I will give it to your lordship in a small note also, my lords. Has your lordship, my lords, got page number 306?
Yes.
Let's hear the discussion is relating to, my lords, dogs and slaughtered dogs and rabies. And my lords, rabies is a final encephalitis with almost 100% case fatality rate. In rabid animals, the rabid virus confines mainly to the nerves and adipose tissues, even though it can also be found in all parts of the body. Transmission is possible following consumption of carcasses of animals that died of rabies and also by consumption of raw dog meat. No intervention is effective in stopping the disease after the onset of symptoms. Hence, there is no need to prevent the disease. Rabies is transmitted by contamination of wound with infectious material, especially saliva, from rabid animals and from bites by rabid animals. In Nigeria, the dog is responsible for over 96% of rabies cases in animals. And then, my lords, your lordship will find at page 315. This is, my lords, relating to people who handle raw meat and the danger to them. I'll give a short note regarding this, my lords. It's all there in the file. And, my lords, just last one judgment had got left, Swaraj Abhiyan, my lords. Which deals with the FSSAI Act in particular, my lords.
Yes.
Passed by my Lord Justice Locus, my lords, with my Lord Justice Ramanna concurring, where my Lord discusses Article 256 of the Constitution. And if your Lordship will, my lords, take page number 181. Has your Lordship got page 181, my lords?
Yes.
My lords, here it starts from, my lords, before my Lord Justice Lokur and Justice Ramanna. The judgments of the court were delivered by Madan B. Lokur concurring, Judge Justice Ramanna concurring, are constituted What can the government of India do to require the state governments and union territories to make functional those bodies and authorities that are mandated by a law passed by Parliament, such as the National Food Security Act 2013? The answer to this is provided in Article 256 of our Constitution, perhaps a forgotten provision, and there was obligation of states and the union. The executive powers of every state shall be so exercised so as to ensure compliance with the laws made by Parliament and any existing laws which apply in that state, and the executive power of the union shall extend to the giving of such directions to a state as may appear to the government to be necessary for that purpose. In other words, the government of India cannot plead helplessness in requiring the state government to implement parliamentary laws. And then, my lords, if your lordship would turn over to page 185 at para 57.
Yes.
Same judgment, my lords. At the bottom of the page, my lords, placetum G, para 57.
Yes, got it.
Since it appeared that the state governments were not at all inclined to implement the provisions of a law enacted by Parliament for the benefit of the people of the country, we were compelled and constrained to require the presence of the chief secretaries of the above mentioned states to inform us whether the law passed by the Parliament is intended to be implemented by the state governments. And therefore, my lords, directions were given at 85. At page 198. States the constitutional principles, my lords. It is to be noted that our constitutional setup mandates that center is not powerless, which is apparent from various articles of the Constitution. Further, it is not proper on the part of the states to ignore the plight of the common man in enforcing such important legislations, more so when such legislation is a welfare legislation. From the table provided above, we have seen more breaches than compliance, which compelled us to call the secretaries, chief secretaries of all the states to appear before us. I am of the opinion that for now, a meaningful dialogue between the center and the state should resolve the issues which have emerged in this case in the spirit of cooperative federalism. The record indicates that a combined effort both by the center and state needs to be taken for effective implementation of the Act, especially in the drought-affected areas, so as to save people from abject poverty and poor quality of life. States should take up this matter with much more seriousness and implement the Act in its true letter and spirit. And just for your lordship's reference, below, the Act under question was FSSA, the people below who were called in court for the chief secretaries. And this is the direction of the court, my lords, in considering the issue of FSSAI and non-implementation thereof, mandating the states, my lords, and more so the chief secretaries in particular, to, my lords, implement the directives in accordance with Article 256 of the Constitution and the higher constitutional vision of the court, my lords, in light of the plight, my lords, of people whose health and safety, my lords, is at stake. My lords, with this, I, for the time being, my lords, would rest subject to, my lords, any. Maybe, my lords, if needed, maybe give written submissions to your lordship, my lords.
Okay.
I'll be brief. Of course, the other side is.
Okay.
Yes.
I'm praying for the respondents want to initially with appeal number 7 on the legislation becoming the judge.
My lord, the state of Nagaland is also my lord's party, so they have to also defend my lords, if we can.
Yes.
My learned friend is appearing for state of Nagaland or my lord private?
Yes, the chief is also represented by the chief lordship resides between first and give to your lordship. For the private respondent.
Yes, you want to address first?
Very good.
Thereafter, you will address. Okay.
Now, we just first address the question as to whether the circular issued by the Food Authority was being now in the petition in the appeal memo, which apparently in the appeal 7. Or the appeal 7. So initially, the petition was filed challenging the intent notification which has been issued by the state government. And in the intent notification, page 138, of the memo. Now, Lordships would see that there's no mention of the Indian circular. Sorry, the circular issued by the food authority. Except only to state that clause 1, whereas the central government Ministry of Health and Family Welfare has enacted the Food Safety and Standards Act 2006 and the Food Safety and Standards Regulations 2011 to regulate the safety of food articles safe for human consumption. Now, during the pendency of this petition, the state had filed their counter affidavit, and in the counter affidavit, the reliance was placed on the circular of 6/8/2014. Accordingly, the petitioner had taken steps to amend the petition, as well in especially the relief portion, and accordingly, the amended petition was filed, and the Lordships will have the amended petition at page 89 of the memo. Oh, sorry, page 227. Starting from page, my apologies. Page 196. 196.
Yes.
Yes, this is the amended petition which has been filed, and your Lordships will observe from the prayer portion of the petition. Page 236. Page 236. These are the reliefs which have been sought for.
Yes.
Yes. Now, the relief A was set aside in notification of 4 July 2020. B, the cabinet decision, and C, sorry, BB, question set aside the letter dated 6/8/2004. This was also impugned, and this has been held to be back in law by the learned single judge. Well, if your Lordship will allow me to take this court to the briefing judgment, page 63. And
page,
the page, I'm referring to page 86. Page 86, paragraph 30. Now, the issue has been very well encapsulated by the learned single judge as paragraph 30. Paragraph 30. The main issue for consideration is whether the Food Safety and Standards Authority of India had acted beyond its delegated powers by issuing the circular dated 6/8/2014, stating that the regulation 2.5 of the FSS regulation 2011 has defined animals, carcass, and meat, wherein sub-regulation 2.5.1a has defined animal. The slaughtering of animals of any other species other than the one listed in sub-regulation 2.5.1a is not permissible under the FSS Act and regulation, and whether, in pursuance of the circular, the state of Nagaland had rightly issued the MP notification 14/7/2020 banning the commercial import, trading of dogs and dog markets, as well as commercial sale of dog meat in markets and dining restaurants. Now, this is the issue. Now, if your Lordship will have the circular, the page 159. One five nine.
59. Yes.
Yes. Now the bone of contention arises from this one sentence, the third paragraph. The authority highlights the definition of animals as mentioned in the regulation and proceeds to draft this line. The slaughtering of animals of any other species other than the ones listed above is not permissible under the FSS Act and regulation. Now this is the bone of contention because such a prohibition is not mentioned in the regulation or anywhere else in the Act. And that is why the petitioner has filed his petition challenging this regulation as well as notification. Now the question is whether this construction as has been placed by the Food Authority is valid in law or not, and whether they could have done this. Whether the regulation which were concerned with the food products, standards, and food additives, whether this regulation contains such kind of prohibition as has been sought to be projected by the Food Authority. That is the issue. Now, in view of this, but before I go into the merits of the case, now, since during the pendency of this appeal, this court had by It's by order dated 11/12/2024. This court had directed the private respondents petitioners to produce copies of the books relied upon by the petitioners. Now, as a prefatory contention, the petitioners have extracted certain anthropological records of the British writers who have recorded the ethnographical records of the Nagas. And wherein, in those records, the culture or the custom of eating dogs, of course, amongst others, the dogs has been recorded. And I have produced those in my petition of Lordship may have Lordship may have the amended petition act. Yes, page 209. 209. Page 209.
Yes.
Yes, this the paragraph under this subsection. I have extracted the relevant portion of the statements made in these books, these antiquities, the Angami Nagas, concerning some of the major tribes in Nagaland, where the culture or the custom of eating dog meats have been recorded. And I also have the books with me, only one copy, but if the lordships would like to peruse that, I can submit it. In the context of Article 371, I would like to make a short submission in this regard.
Okay.
Or if it's not necessary, then I can always rely on the livings making the institution.
Okay.
Now, I will not be reading them out, but I have recorded the book by J.H. Hutton, the paragraph 5.1 of my petition. This is with the and where these references have been made, and I have extracted them. And at page 210, again by J.H. Hutton, pertaining to the Sema Act, in the book The Sema Nagas, published in 1921, again, where the dog, the meat of the dog is considered as a tonic, even then and even now. At paragraph 5.3, the book by J.P. Mills concerning the Ao Nagas, another tribe, another major tribe. And on the next page of my petition.
But how this argument will help you?
No, just to, of course, this is not part of my main argument, but I have just to show this quote that to show that the culture and the custom which have been practiced since time immemorial.
That's all right, but the state of Nagaland has seems to be adopted this act.
Yes. Now, in that context, the lordships will have 371A.
Now that is there. But so far this rule of executive business is there. It appears that the state has adopted the act. No, the legislature has not adopted, but it is mentioned in this rule of executive business.
Whether the rule of executive is it's 2025 or
2020. It is of 2020.
Lordship request in mind. 25 to 2025. This was sent to me by the Secretary General Legislative Assembly, saying that the food safety
Act has not been adopted by the Netherlands. If you are, we are confessing if you are free.
But in this role of executive business, it has been mentioned that who is the implementing
Yes,
authority
yes.
of that act.
Yes.
So though,
Directly.
though it is not explicitly adopted by the state legislature, yet it appears that impliedly the
Yes,
state
they-
has.
No, no, they will keep that since it was.
Yes.
enforced. No.
Yes. Yes.
But this not being a primary submission before the other single judge, I would submit that if the circular is wrong, because in the regulation, the lordships will see, and I'll show you, in the regulations, there is nothing to show that the species of animals which are not mentioned in the definition cannot be consumed. There's nothing as such. But it's a circular which have got this construction. Therefore, if this construction is correct, or if the circular is correct, then 371A will be applied. Because of course, fooding habits being a part of the social practice, it will be applied. And therefore, in that view, the state assembly will have to pass a resolution to the effect, to that effect, only that. Or else, if the circular is, if lordship agrees with the other single judge, then in that case, there's no need to pass a resolution for adopting the event. That's the prefatory submission that I would like to. If the circular is correct, in that view, 371A will be affected. If it is wrong, as held by the other single judge, then there is no question of adopting a resolution. Now, the primary contention being raised by the petitioners. My apologies. This. I'm submitting that the circular issued by the Food Authority restricts the definition of food as has been defined in the Food Safety Act. And that's the first submission that we have. Now, the Lordship, they have a Food Safety Act and they produce the definition of food at section 3, subsection J, 3J.
Section
3, and then the definition of section J, 3J. It defines food, not just a product.
3G.
3J.
Food.
J. Food means this is the first part of the definition. Food means any substance, whether processed, partially processed, or unprocessed, which is intended for human consumption. Now, this definition has been borrowed from one of the Food and Agriculture Organization, along with the World Health Organization. They have some set of codes to implement this. Now, this part of the definition has been borrowed from them. It says food means any substance, whether processed, partially processed, or unprocessed, which is intended for human consumption. And therefore, the contention being that the Food Authority, being a creature of a subordinate legislation, could not, by issuing the circular, could not restrict the definition of this, definition of food. Because if your lordships will have the meaning of substance at ZW, the meaning of substance is also provided at ZW, section 3 ZW. And you define substance to include, yes, substance.
Section?
ZW, 3 ZW.
Yes.
Substance includes any natural or artificial substance or other matter, whether it is in solid state or in liquid form or in the form of gas or vapor. Now, ideally, any meat of any animal would be a natural, a solid substance. Therefore, the definition of food is wide enough to include the meat of any animal, as long as it is not prohibited under any law for the time being in force. Now, my learned senior friends have advanced a contention to the effect that lions, tigers, and everything, but those are all prohibited under the Wildlife Act. And I also made necessary pleadings to that effect in my petition, state that the Wildlife Act under Schedule 2 it prohibits wild animals which cannot be hunted or slaughtered. And all those restrictions are provided there. So this has to be looked into that context being important. Now, the second part of the definition of food goes on to say that it includes primary food, which has also been defined, which I'll not be touching upon. And also it specifies what it does not include. What does not include any animal feed, but does not include any animal feed. Number 2, live animals, unless they are prepared or processed for placing on the market for human consumption. So the question is whether this definition of animal, as has been provided in the definition of food, whether we can incorporate the definition of animal in the regulation to this definition. Now, that is also part of the contention.
But you see that notification of the central that food authority of India is upheld by a coordinate bench of
No, that's incorrect. That's an incorrect statement because that case did not deal with the question which I'm raising in this petition. And in paragraph 31 also, the court has clearly stated, but my learned senior friend had conveniently omitted to say that, to read out the portion. If I may. This 2022 SSC online, Gauhati page 50. Paragraph 31.
Yes.
Now the subsequent notification here in this case by the Animal Welfare Board, it was also from the intent was borrowed from this impute circular. I will not be reading out those, but if you lordship will have the end portion of the paragraph 31 in the next page. After reading out the content, this part of the and the letter dated 7/6/2022 of the AWDI has mentioned that the definition of animal has effectively meant that camels cannot be slaughtered for food at all. This part of the directive contained in the letter dated 7/6/2022 has not been assailed at the petitioners in this petition. So this was not an issue before the court bench. Whether by virtue of the construction in place by the food authority to the effect that animals which are not mentioned in the definition, the consumption of any species of animals will be prohibited. This part of the issue has not been raised in this petition. Therefore, the court did not have an occasion to address this question. Now, in view of that, this will have now the concern regulation, the regulation of 2011, food safety. The Food Safety and Standards, Food Product Standards, and Food Entities Regulations, 2011.
Yes.
The Lordship says, food safety standards and regulations.
Regulation.
Yes, the food product standards and food additives regulation for 2011.
Yes.
Now, in the first rule, 1.1, in the proviso, Lordship may have it.
1.1.
1.1 provided
One point one.
Yes, in regulation 1.1 under the title and commencement, under the heading title and commencement, in the proviso. The proviso reads, provided that wherever the standards given in these regulations are at variance with any of the provisions of the licenses already granted, food business operator shall comply with the provisions of these regulations within 1 year from the date of commencement of the regulations. Now, I would like to submit that this regulation is only intended for the food business operator to comply with the standards which have been laid down in this regulation. It has nothing to do with what the citizens want to consume. And it is only for the food business operators to comply with the standards. Now, if your lordships go through this regulation, your lordships will find that it is very technical. It deals with manufacturing, the how to package, what ingredients to use, and this regulation has dealt with various articles of food. And
yes,
starting with chapter 2. It's extremely important in lordships because lordships will have to know what this regulation is about. Starting with chapter 2, dairy products and animal. Now, I'm not really taking lordships to all this, but in
chapter 2 at page number of this book.
Yes, lordships.
20. Page number of this book. 202. 202.
Yes, 202.
Yes.
Now, this deals with dairy products, and if the lordships will go through, then it specifies as to how the food business operators are to manufacture their products, following the standards. Everywhere, there are a huge number of food articles which have been listed in this chapter, and the meat section also comes under this. Now, meat and meat products falls under regulation 2.5 at page, if your kids are having the same diagram as mine, 411. 411, page 411.
Or 11.
411.
Yes.
411G. G.
Yes.
Now, here is the definition of animal, where it has been listed. Animal means an animal belonging to any of the species specified below. And then it lists out these vines, capons, and includes poultry and fish. Now, the domestic rabbits at clause 5, it was added subsequently. But the submission being that even just because these animals are listed cannot mean to say that the animals which are not listed here cannot be consumed, because nowhere has such construction there in this regulation. But the contention is that these animals which are listed and which follows along the regulation, the lordships will see that it is only meant for the food business operators who are involved in the manufacturing or production or selling of the meat of these animals. They have to comply with the standards. That is it. Just because an animal is not mentioned does not mean that the consumption is prohibited. Lordship may have the
No, whether such kind of interpretation can be adopted.
yes, of course. Because as I already pointed out in the circular, that one of contention, that sentence. Whether that sentence is found in this regulation and whether this regulation contains such an intention or whether expressly or impliedly, Lordships will find nothing.
Maybe in that case, we have to go the statement and object of the act.
Yes, that is what I have taken the Lordship just to all the statements to the preamble also. But in view of paucity of time, I refrain from taking Lordships to all those. And since your Lordships have mentioned that statements of objects, when this act was enacted at section 97, the repeal provisions, it repealed the prevention of food adulteration along with other orders. Right. Now, in Schedule 2 of this act, it mentions these 8 acts and orders which have been repealed. The definition of food under the prevention of food adulteration and the definition of food contained herein is different. That is why I have earlier stated that this definition, the first part of the definition, where it says food means substance, any substance, is borrowed from the FAO codex. Now, in this second schedule, if your Lordship may have that, since your Lordships have pointed out the statement subjects, allow me to take Lordships to page 71 of the text. 71, Lordships will see in the second schedule. These are the acts and the orders which have been repealed. The orders being issued under the Essential Commodities Act. At serial number 3, it mentions the Meat Food Products Order of 1973. And this has been repealed. That it will be interesting to note that the Meat Food Products Order contains the same definition of animal since 1973. I have a copy.
Yes.
No, in the definition, Lordships will see. Animal means an animal belonging to any of the species specified below, so and so on. It's the same. Since 1973, this has existed. It's nothing different. What changed? That is the question. If this had been in existence since 1973, there was no reason for the authority implementing this meat products order not to have issued this. But I don't want to make this a political submission, but there was a change in the dispensation in 2014. Immediately after the change in the dispensation, this circular was issued in the central government by the food authority. That is actually correct. Prior to 2014, no such circular has been issued by any of the authorities implementing this. This definition has existed all along. Now, therefore, in my contention, it's basically
maybe, and now they have issued it.
No, but the question is whether the construction has been placed in the circular, whether that is correct. Can such a construction be placed in the circular, and whether the regulation contains such a prohibition that because the definition of animal contains certain species, beyond such species, the citizens cannot consume, or that any species of such animal is not fit for human consumption. That is the question. And for which your Lordship has also rightly pointed out the statement of objects, the preamble, and the principles of sovereign legislation will come into.
No, that's all right. But if it is injurious to the human health,
yes,
then
in that regard also, if it is to be injurious, then it has to be backed by scientific data. Nothing as such exists.
No,
there's no record to show that.
Ms. Pinky Anand had pointed out to some of the research papers.
But those are not of India, those are not of food authority. Foreign authorities, documents they are relying on. And those research papers are not even relied by the food authority. The circular was issued very blindly. The construction does not, if your Lordships look at the regulation, the consent regulation of 2011, it does not behove such an interpretation or such construction to say that just because these animals are mentioned, you cannot eat this. That is beyond the scope of the food law, beyond the scope of the legal legislation, because the act, the parent legislation defines food in such a wide, to have such a wide meaning. Now the supplementary legislation, by way of the legal legislation, cannot restrict the definition of food. If we are to accept the circular to be as correct, then we will be limiting the definition of food as found in the act, which is contrary to the principles of subordinate legislation. It's one of the principal contentions which have been advanced. Now, therefore, as far as the regulations are concerned, the submission is that the standards which have been specified in these regulations, your lordship can kindly go through. Lordship will see that it is mainly intended for the food business operators to comply with the standards which have been made down. Just because some animals are not found does not mean that they cannot consume. It simply means that the standards have not been laid yet. Prior to the inclusion of domestic rabbits, the standards was not specified, but that did not mean that the citizens cannot consume domestic rabbits. They still consumed. But the standards for the food business operators to manufacture, process meat of domestic rabbits was not laid down.
It has to be regulated.
It has to be regulated. Now, it's only for this purpose that this regulation operates, for the food business operators. It does not restrict the right of the citizens to consume food, any animal, any meat of any animal. It does not restrict that. That was straight away by Article 21. And as part of my corollary submissions also, I relied on this. The right, the choice to consume food of any choice, the choice to consume food is a facet of the right to privacy, as well. So those factors.
Right to privacy?
Yes, as laid out in I have the judgment draft. They have put us on judgment. The choice to consume food of any choice. Food. The citizen had the right to choose what type of food he wants to eat. And now regarding the food since we are concerned with dog meat as being unsafe. Now, the lordships will have the act at section 48. Procedures have been laid down as to how the food authority is to function, or any of the authorities appointed under the act are to function in determining whether any food is unsafe or injurious to human health or human consumption. 48 subsection 2. In determining whether any food is unsafe or injurious to health, regard shall be had to the so and so. And also, the lordships will like to notice that in section 30, this is this talks about the powers of the Commissioner of Food Safety. Section 30. It says the state government shall appoint the Commissioner of Food Safety for the state for efficient implementation of food safety and standards and other requirements laid down under this act and the rules and regulations made thereof. The Commissioner of Food Safety shall perform all or any of the following functions, namely, or A, prohibit in the interest of public health the manufacture, storage, distribution, or sale of any article of food, either in the whole of the state or any area or part thereof, for such period not exceeding 1 year, as may be specified in the order notified in this behalf in the official gazette. The other functions are not reading now, but this is the relevant provision as far as this case is concerned. And then in section 32, the improvement notices. Section 33 is the courts can also issue prohibition orders.
So what wrong with the order issued by the Central Food Authority?
It is wrong because such a construction is not there in the regulation of 2011. The animals defined therein it is only for the purpose of the food business operators to achieve those standards which have been laid down in the regulation. That is it. It does not mean that the other animals which are not specified in the definition of animals cannot be consumed. But the food credit goes
No, whether no, the question is whether such a construction can be placed in the
no, because it cannot be, because that's why I was submitting that the regulations, the context of the regulation have to be looked into. The meat, dairy, or the fish products, how the standards are to be obtained, food for the food business operators, everything is mentioned. And before the learned single bench, I have taken the learned single judge faithfully to all these provisions, how the food business operators should comply with the standards that have been laid. And therefore, in that context, the submission being that just because the animals are mentioned, certain animals are mentioned, does not mean that the consumption is restricted to only those. The lordships will not find any such expressly or impliedly the construction as has been placed in the circular. The lordships will not find. It is outside of the regulation, and that is why the submission being that the circular is authorized the act, and as has been rightly held by the nursing judge. It is authorized. By raise the principles, if we are to accept that the circular has been correct, then the definition of food will be restricted. The intent of the regulation is violated. Subsequently, Article 21 is violated. The act is not intended to control or to dictate what the citizens can eat, cannot eat. That is not the intent of the act. If you don't just go through the statement of objects, it was to have a safe and wholesome food for the citizens. The statement and objects clearly lays down there. 4 paragraphs. Now, the second link of my submission is if we are to accept the circular as being correct, as being the true construction of the regulation, then the other principle, it violates the other principle, which is that delegated legislation cannot be in violation of other statutes also. It has to be in harmony. We have to be able to read in harmony. Now, lordships may currently have prevention of cruelty to animals. Before that, may I just cite one authority? Two 2006 for SCC 327.
Can I pardon, please? Can you? Sorry, my lord.
Yes.
Citation, please.
Yes. 2006 for SCC 327. 2006 for SCC 327. No, 6 for CC 327. 6 for. I'm relying on paragraph 17 for that principle. Number 17.
Yes.
A rule is not only required to be made in conformity with the provisions of the Act whereunder it is made, but the same must be in conformity with the provisions of any other Act, as a subordinate legislation cannot be violative of any plenary legislation made by the Parliament or the state legislature. So this regulation cannot be in violation of any other parliamentary acts which have been made. Now the definition, Lordship will see now. Under the prevention of cruelty to animals, the definition of animal, there are as follows. Section 2A. Section 2A.
Yes.
Yes. It defines animal 2A. Animal means any living creature other than the human being. That is. Now, under the Prevention of Cruelty to Animals Act, we have the slaughterhouse rules. The Lordships may have the slaughterhouse rules, the Prevention of Cruelty to Animals slaughterhouse rules of 2001.
Yes.
Under the definition slaughter, 2B. Slaughter means the killing or destruction of any animal. Now, of course, in this, as far as this act is concerned, the act has itself defined the meaning of animal. Therefore, there's no difficulty. The destruction of any animal for the purpose of food and includes all the processes, operations performed on all such animals in order to prepare it for being slaughtered. And therefore, slaughter means the destruction of any animal for the purpose of food. Slaughterhouse again, I will not be reading it out. Now, rule 3. No person shall slaughter any animal within a municipal area except in a slaughterhouse recognized or licensed by a concerned authority empowered under the law for the type of force. Now, the petitioners being dealers in supply of dog meat, they slaughter their house, slaughter the dogs under the rules as has been provided by the minister. Now, therefore, if the circular is taken to be as current, will it not be infringing on the Prevention of Cruelty to Animals Act? Because here, under the Prevention of Cruelty to Animals Act, animal means any as long as it's not a human being, and as long as it's not prohibited by any other law for the time being, it means any living being. The Act itself defines. So there's no difficulty in coming to any conclusion what an animal is. Now, therefore, in a slaughterhouse, and any animal is being destroyed or destructed for the purpose of food, there is no prohibition as such under the Prevention of Cruelty to Animals Act if dogs were to be slaughtered for the purpose of human consumption. There's no bar as such. Now, this incongruity cannot be harmonized if we are to take the circular as incorrect. It cannot be harmonized at all. Therefore, as well, the learned single justice rightly held that this impugn circular was bad in law. Now, as far as the powers of the Chief Secretary, the powers of the executive, as far as those are concerned, I will not be making any further submission except to rely on the relevant paragraphs of the learned single judge. Before that, At paragraph 34, page 90 of the judgment, page 90.
Page
90.
Yes.
This was the conclusion arrived at by the nursing judge. Allow me to read this paragraph. A perusal of Regulation 2.5 of Regulation 2011 shows that it provides for a detailed procedure as to how the need of the animals defined under Regulation 2.5.1a is to be processed scientifically to make the meat of the animals safe and suitable for human consumption. Thus, the regulation deals with only how to process the animals mentioned, and there is no provision in the regulation prohibiting the slaughter of any other animal for human consumption, not mentioned in Regulation 2.5.1a of the Regulation of 2011. On the perusal of the FSS Act 2006, the definition of food is given under Section 3G, and wherein primarily food would mean any substance, whether processed, partially processed, or unprocessed, which is intended for human consumption. This definition is wide and liberal enough to include dog meat, since the Act has not defined animal as defined in the regulation. It is seen that sections 33 and 34 provide for certain circumstances under which prohibition notices/orders can be passed, which are, however, not prohibiting the slaughter of any other animal for human consumption, not mentioned in Regulation 2.5.1a of the Regulation of 2011. The Food Safety and Standards Authority of India was delegated the power to ensure availability of safe and wholesome food for human consumption by making regulations consistent with the Act. On perusal of Section 16 of the FSS Act 2006, wherein the duties and functions of the Food Authority is listed, it is seen that there is no mention of power to issue prohibition orders by Food Safety and Standards Authority of India. Thus, it appears that the Food Safety and Standards Authority of India have acted beyond its duties and functions under Section 16 of the FSS Act. So this was the conclusion right here. And insofar as the powers of the Chief Secretary are concerned, there is nowhere mentioning Act that the Chief Secretary can issue any notification or orders to that effect. I'm relying on paragraph 35. I'll not be reading them out, but paragraph 35 to 6
But the State Cabinet has authorized the Chief Secretary to issue such order.
Yes. But this submission is alternative to my own submission. It is my alternative contention that even if there was no act as such, even if we have no Food Safety Act, then in that view also the executive, the government cannot by an executive violate Article 19 and 21. So in that view of the matter, it was submitted as an alternative submission that the Chief Secretary could not have issued. It's mentioned in my pleadings also, so I will not be taking notice to all this. Lastly, regarding the right to privacy, in relying on Futuswami's judgment, reported in 2017, 10 SEC 1, 2017, 10 SEC 1. While making the submission was the lordships are well aware that this act applies all over India. It's not just in that. It will not be proper to assume that the citizens of India consume only these types of animals which are specified. We have the tribes, we have the communities that exist in India. We cannot assume that we consume only these types of animals. Therefore, in that view, the application of the act, the wrongness of the circular has to be looked into. And that's why the argument for privacy being that in the judgment referred to at page I will just be reading out the relevant portion only, page 499. Page 499. This is paragraph 298, just below question B. The words, the freedoms under Article 19, just below question B, starting with the freedoms under Article 19.
Yes.
The freedoms under Article 19 can be fulfilled where the individual is entitled to decide upon his or her preferences. Read in conjunction with Article 21, liberty enables the individuals to have a choice of preference on various facets of life, including what and how one will live, and the way one will dress, the faith one will espouse, and a myriad other matters for which autonomy and self-determination require a choice to be made within privacy. Now, therefore, the choice to consume or the choice to believe that dog meat is a tonic, I'm submitting that it is a facet of the right of privacy. And therefore, it is the impute circular grossly erodes this choice if you were to take the circular as being correct. And even in his concurrent judgment, at page 598 and of Justice Ranton Funny page 598 in his concurrent judgment. The paragraph 521. 521. Sorry, page will be 598, paragraph 521.
Yes.
Yes, His Lordship President, but in the Indian context, the fundamental right to privacy would cover at least the following three aspects. The privacy of choice being the third one. Privacy of choice, which protects an individual's autonomy over fundamental personal choices. Therefore, the submission is that this act, at the cost of repetition, is not intended to restrict or prohibit what the citizens of India can consume. It is not. And it cannot be also. But what the regulation, what the impute circular tries to do is it tries to restrict this, tries to give a new meaning to the act, the regulation as well, which cannot be countenanced. And therefore, in view of the submissions which have been made, it is violative of the principles of supplementary legislation, as well as violative of the Prevention of Cruelty to Animals Act, and such construction has been placed by the Food Authority. It's not found anywhere in the Act or the regulation itself. Therefore, the learned judge has rightly set aside the impute notification and held the impute circular to be as valid as being violative, as being outside or ultra-virus duties of the Food Authority. I'll address my submissions with that. I'm much impressed.
Your correspondent number?
Lordship, I'm for respondent 123 in writ appeal 12 of 2024, my lord. The issue is basically the same, even in this writ appeal. And
so the same judgment and order is being challenged.
So this supplement these contentions from first, Lordship, is that if my lords were to produce the Food Safety and Standards Act, the Act is bereft of any provisions wherein the Food Safety Authority is empowered to ban permanently any food or any item that the citizens consume as food. Right? So the Act is most comprehensive.
Even if it is injurious to the public health.
Yes, certainly. But if it is injurious, what should be done? Kindly permit me to take my lords to such provisions, Lordship. If my lords will have section 18 of the Food Safety Act. So this is under chapter 3, general principle for food safety proof. Since the sections are also quite long, I'll just take my notes, the relevant one. Section 18F, my lord. In cases where there are reasonable grounds to suspect that the food may present a risk for human health, then depending on the nature, seriousness, and extent of the risk, the food authority and the Commissioner of Food Safety shall take appropriate steps to inform the general public of the nature of the risk of health, identifying to the fullest extent possible the food or type of food, the risk that it may present, and the measures which are taken or about to be taken to prevent, reduce, or eliminate the risk. So, the section is self-explanatory, and also my learned friend has taken my notes to section 30, section 48 earlier, where in cases where certain food items present to be a risk, then the food commissioner has been empowered to ban sale of such food for a period of 1 year only, and also under section 48. Under section 48, my learned friend has also highlighted that earlier. There, the procedure has been prescribed as to what action and what is to be done if a certain food is to be considered unsafe for human consumption, my lord, as opposed to just randomly banning and prohibiting consumption of such food, my lord. There is no such provision, Lordship, insofar as this act is concerned. And therefore, my first proposition is that the food safety, Lordship, is confined and bound by law and the powers that have been granted to them under the Food Safety Act.
Mr. Singhvi, are you there? Mr. Singhvi? Mr. Singhvi, are you listening? Yes, madam, are you listening?
Yes, my lords, we have been listening. We appear for the appellants and we are led by Miss Pinky Anand.
Okay. Okay.
Yes, my lord.
Okay.
Yes, my lord.
Okay. Yes, please continue.
So, my next point is that food is something that is very subjective in nature. Or food is something that is that provides nutrition and nourishment to one that consumes it. Food is Lordship, I read the Mushahar's Dalit of Bihar, arguably the most marginalized community. Dalits, they consume and rare rats for nourishment and nutrition. In the same way, here also, Naga people we've been consuming dog meat for nutrition and nourishment for the longest time. I will not be getting into details of that. My learned friend is surprised by lots of that argument earlier. So, on that line, I'd just like to present two decisions of the Honorable Apex Court where food has been defined. This is 1989 1 SCC 354. Okay. A small observation that the Supreme Court has made. I just highlighted it as a watching for convenience. But food is one which
Paragraph number.
Paragraph 6.
1989 1 SCC, sorry.
Yes, it is 1989 1 SCC 345.
Okay, thank you.
That's my lordship.
Paragraph number?
Paragraph 6 from the second sentence, please.
Yes.
But food is one which nourishes and sustains human body for the purpose of growth, work, or repair, or for the maintenance of vital process. So that is the very short point that I wanted to make. That food is not something which the government will declare for the people. It is something that the people will choose. It is something that the people will voluntarily consume. Yes. And another argument, another decision in this regard is one decision. This is also by the Supreme Court, 1974, 1 SCC 167. 1974, 1 FCC 167. If my lords will have paragraph 14 at page number 176. I flagged the 11 page. For paucity of time, I will not be reading out the entire paragraph, lordship. May I proceed?
Yes, paragraph number?
Yes, page 176, paragraph 14. Paragraph 14.
Yeah.
The Act defines food very widely as covering any articles used as food and every. I'm sorry, Lordship, it's just from the next sentence. It is commonplace knowledge that the word food is very general term and applies to all that is eaten by man for nourishment and takes in subsidiaries. Lordship, yes, Lordship, this is also an observation which may be relevant for this case. In this case, it was held whether supari was food or not. And therefore, since supari was also considered to be taken by man for taste and nourishment, it was considered food by man. Yes, I think. Lordships know that there is a maxim. Everything that is not forbidden is allowed. There is no law prohibiting any person from deciding what is to be considered food and what you should not consider as food. Lordship. And to that effect, even here, my contention is that there is no statutory provision under this law which states that, more particularly talking in this context, the law does not state in unequivocal but there is that I cannot consume dog as a source of food, and therefore, within such parameters, this maxim applies even for me. There is no, it is not forbidden, and I am permitted to do so. And to support that contention, on that maxim, I just like to furnish another decision of the High Court of Madhya Pradesh. I like the relevant portion. It is at page 1403. This is a decision.
Can you please?
Madhya Pradesh, ILR, IL 2019, MP 1397.
MP page
1397.
Thank you.
14th paragraph at page 1403. The court proceeds to examine as to what makes any law, any act lawful or legal, and in the converse, what is unlawful and illegal. Where the law permits a certain act, there is no doubt that doing of that act would be legal. Similarly, where the law prohibits a particular act, the doing of that act would be illegal. However, where the law does not explicitly permit any act and neither prohibits it, or in other words, where the law of the land is completely silent about the legality or the illegality of the act, would the doing of that act be unlawful only because it is at conflict with the contemporary laws of the society and any overwhelming preponderant public perception of what is right, the liberty of an individual to act in any manner where such an act is not prohibited under the law is unfettered and unquestionable. Another judgment, one last judgment to on the same point, my lord.
Not necessary to multiply the decisions on the same point.
Now coming to the contention in Plea Appeal 12 of 2024, the appellants have imposed various articles which pertain to Hong Kong, China, Taiwan, South Korea, Philippines. However, there is no data to the effect indicating that consumption of dog meat has led to the cause to the spread of rabies in the state of now. I personally do not consume, but Lordship, there is no complaint whatsoever from any consumer of dog meat as the cause of rabies to this day, Lordship. My point being, Lordship, that even if my lords, we kindly annexure 10 of the writ appeal, Lordship, 272. It is at page 272. It is quite voluminous. I do not intend to take my lord's view whole thing, but here at this is annexure 10 at page 272. The relevant portion is at 273. Lordship.
Writ appeal 12.
Yes.
Writ appeal 12.
Yes, my lord. This article is titled Animal Welfare in Hong Kong, and the relevant portion which I because my lord's
Paragraph number, sorry, page number
273, my lord. Relevant portion.
273.
Yes. Okay. 273, second paragraph. Prohibition against eating dogs.
Yes.
Yes. Kindly permit me to this paragraph. One of the most interesting side issues during the development of our legal framework in preventing animal cruelty concerns our ban against the practice of eating dog. The consumption of dog meat used to be popular in Hong Kong. However, in the early 1950s, our government already outlawed the practice of eating dogs. Poon Chang Hua is an associate professor of the Department of History at the Chinese University of Hong Kong. Her article, Dogs and British Colonialism, the contested ban on eating dogs in colonial Hong Kong, traces the history of this ban. She suggests that the dog-loving elites skillfully manipulated the outbreak of rabies in 1949 and the rabies panic to their advantage by petitioning our government that the practice of eating dogs was conducive to the spread of rabies. But it is my humble contention that even in this circumstance, the petitioners, they are not based in our margin. It is basically dog lovers and elite dog loving community that is pressing for this legislation, for this order, for this ban under the garb of rabies. So that is contention that I beseech my lords to kindly consider also. But now coming to my yes. The petitioners in writ appeal 12 has made multiple affirmants that there is violation of slaughterhouse rules, transport animal rules. But in that regard, there are adequate provisions of law in place to address all these grievances. Paragraph 13 of the petition, paragraph 14, paragraph 18, the violation of the rules have been very agitated. And but I do not need to give an explanation on details of slaughterhouse rules or the transport of animal rules 1978, but just to give my lords a bird's eye view. Slaughterhouse rules, so many things, it's more comprehensive in nature. Animals are not to be slaughtered outside. Veterinary doctor, you examine animals, fitness certificate of animals, proper ramps to be constructed, animals not to be killed inside of another, blood not to be splashed on other animals, details of blood drain, the drainage, specification of building, etc. It is most comprehensive. Everything is provided for. And in the transport of animal rules, it provides for animals, all of them, particularly cats, dogs, monkeys, cattle, pigs, poultry, etc. How a certificate by a veterinary surgeon must be issued before they are transported. If there is no certificate to that effect, the transportation ought to be rejected. Pregnant animals are not to be transported. Water, how they are to be caged and they are to be transported. All details are there, my lord. So, is it the case of the appellants that the transport commercial sale should be banned because the transport rules and the slaughterhouses are not followed?
No, that aspect was not dealt with by the.
However, yes, if my lord feels it's not required, but since they have made such agreements,
No, maybe
not. In that case, lordship, anyway, to close that argument, lordship, If they are so concerned about this, why is there nothing on record to show what they have done, what complaint have they filed before any state authority to address all this, Lordship? And the single judge have also made certain observations that, yes, instead of sending this order in this way, the steps could be taken by the state to address these grievances. Lordship, coming to my final argument. An averment has been made by the appellants that these rules have been duly published in the Gazette. Public opinion was called for, we've kept quiet this whole while, and now, Lordship, in that regard, the rules, my learned friend has referred to those 2.5 of the rules, the animals have been defined, Lordship, overrides cabinets, all this, but the rider, the proviso in the letter by the union that the slaughtering of animals of any other species other than the one listed above is not permissible under the FSSF. This is something that came out of the blue. Suppose if this had been published, then perhaps objection would have been raised at this time, because this is the wrong construction of the power that the power that has been given to the food authority. And therefore, to sum up, it is the case of the petitioners that due procedure should be followed. The Food Safety Act prescribes procedure as to what should be done if a food is considered unsafe. Commissioners are there, the food analysts, experts are there. The provision prescribes that they are to extract samples, they'll send tests, they'll inform them that these samples are being extracted so that they will be examined. And if at all the authority, commissioners, all this, they're satisfied that it is indeed injurious for consumption, then the commissioner is to pass an order under Section 30 of the Act, whereby the sale of such things will be prohibited for a limited period of time, as opposed to a certain number of time. So, yes, that is the case, and we will be more satisfied if the state handles this problem as per the procedure prescribed in the Food Safety Act. That is fine.
Yes, madam.
Since the state has not filed any appeal, I have not much to say, but I want to take my lord to the paragraph as to how we brought out the notification, appeal notification. Motion may turn to page 150 of appeal number 7. 150 of appeal 7.
Yes.
And please go by paragraph 205, the last. I mean, the last-
150.
Yes, page
Okay.
150. The last paragraph is 3.5. That the regulation of the instances coming to light of import or commercial sale of dogs and dog meat in the state. The cabinet observed that dog meat falls within the family of canine, which is excluded from the provision of regulation 2.5 DA of FSSAI regulation 2011, which regulates and defines the meat for sale and consumption. And thus, the existing law does not permit the disclosure, sale, and consumption of dog meat in the country. The cabinet, after due deliberation, decided for issuance of orders banning the following commercial import and trading of dogs and dog markets, 2, commercial sale of dog meat markets and live restaurant. So you noted the reason why we brought the notification 47/2020 is that dog meat comes within the family of canine, which is excluded from the meaning definition of animals under FSSI. Apart from that, since the state has not filed an appeal, I have not much to say about it.
Mr.
But,
Sikri,
Yes, sir.
tomorrow at 2 p.m. we will list the matter.
Very well, ma'am.
Can you make it convenient to appear?
My lords, I would, but
If there is any spillover, I will, otherwise I will attend, my lord. 99% I will attend, my lord.
Okay, yes, madam, whether Pinky Anand
I
can.
will attend.
My lord, the matter may be taken up next week for the continuation of these arguments, my lord.
No, sorry, madam,
For
next
any
week, one of
rejoinders.
my brothers also will not be available here. So we have to complete it within this week.
Tomorrow, my lords, I will come at 2 p.m.
Very well.
Address, my lord.
Okay.
My lord, if it can be on 11th of February, my lord,
No, sorry, madam.
for the
On
continuation.
this bench will not be available here.
Well.
Okay.
My lord, then
2 p.m. my lords, tomorrow?
Tomorrow
My
at
lord,
2 p.m.
examinations be, yes.
Okay. Heard in part, list the matter tomorrow.
It is not a statement.
Any other matter?
No.
Okay. Mr. Iralo, the citation you have relied upon, you give the list to the court master, and you also.
And
My lord, maybe also get a
tomorrow
copy
also,
of
my lord,
the
the
my lord.
council at there, my lords, so that sometimes we have missed out in writing, my lord. If they can give it to my council at.
Okay. Give a copy to him also.
My lord, as well as to Mr. Medovera, my lord. For us.
Okay. Yes.
Thank you, my lord.
Yes.
Thank you.
Oblige.